It's all good now.
Oh, we have new TV screens.
Hi, good evening. It's November 15th, 2018. We're at the Littleton Zoning Board of Appeals. It's 7:15 PM. I will open the meeting for tonight. We're at 37 Shattuck Street, room 103, Littleton, Mass. And the first thing on the agenda at 7:15 is administrative matters. Are there any bills to sign? Any correspondence other than that pertaining to the cases tonight?
Nothing?
And we have one set of minutes. Is that it, just once?
Yes, just the one.
What happened to August? Did we approve that last time?
No, we didn't. No,
Okay. Go back. I need to approve a voting alternate for the minutes. Let me remind myself who might have been here to read them, to vote on them.
whoever has them in their packets. You vote on them.
Yeah, we don't have Mark here.
We don't have Matthew. I know I read it and approved it. I don't know where I put it.
Are you looking for this?
Yeah, but I already did mine. Okay.
Oh, you marked it up.
Yeah, well, no, I didn't have any comments on it. Okay, I have it. So who's in one? Alan, were you here, Alan?
Yep.
Jeff?
Yes.
Me? Rod was not here?
For this October. Rod was here.
October. You were here, Rod? And John, you were here. So John, be the voting alternate on the minutes. Anybody have any changes?
Oh, there's other in the packet.
I thought you did a good job on it, Janet. It was a suggestion of mine that the minutes can be a little bit less detailed because we now have recorded transcripts of everything. And rather than have every single he said, she said within the minutes.
Plus, I like the
just a bit-
snappy graphics.
just a bit
Bold
chicken.
face, bottom line.
I do like the identifying the voting members too who voted and moved and seconded. That Shelley used to always do too. But-
Is that true? There was a yap here?
Yeah, oh, that was yeah, you're right, that was the one correction. That should probably say applicant and not Yap. It might have meant Jeff Yates, but I don't
Yeah,
think
that's what I was
Yates.
wondering.
But I don't think it should say Yates presented, it should say the applicant presented. So it's right here.
Oh, yeah.
Yeah. Applicant
I
stated,
think that is me.
yeah, but I think it should say
Yeah. there's no
applicant
yeah.
stated that when he applied.
Okay.
Can you just make that one change? Thank you for catching that. Okay, everybody who wants to make a motion to approve them as amended?
So moved. Second.
Rod and Alan? All those in favor signify by saying aye.
Aye.
Opposed? Okay, the first hearing tonight is, according to the agenda, 61 Aspen Road. I can't open you till exactly 7:20, but if you come forward to present, and this is one of you, okay? So the process for everyone who's here is that the applicant presents their case. The board will then get to ask questions, and then we will hear from any comments from the building inspector and the assistant building inspector who are present tonight. We'll then ask for abutter comments, and then the applicant will have a chance to speak again, and the board will have a chance to continue to ask questions, and then the board will deliberate and vote. We just requested to address everything through the chair and to be respectful. We do this a little informally, so give me a minute to open you, and then we'll do it informally. Any second?
There.
Okay. Do you want to open it? Do you want to call it?
Not really.
No?
I thought that was the chair's job.
Going to give somebody else a turn. Okay, at 7:20 PM, I'm opening the hearing of case number 908A. The petitioner, Christina Riordan, requests a special permit or a variance pursuant to Section 17310B, non-conforming uses and structures, and Section 17331, intensity of use schedule for a proposed screen porch and deck with a reduced street and side setback at 61 Aspen Road. I'm keeping a little chit chart here of alternates that I appoint to hearings, and so you just happen to sit in the right order. John Sewell, you're the first case tonight. Okay. Appointing Sewell as the alternate. Go ahead, please.
So if you have the plot plan in front of you, I just wanted to point out that Aspen Road is actually only a paper road. It is not a paved road at all. It runs through the woods, and actually the roads Washington and Orchid that cut down on the either side of the lots are also paper roads. So although the variance is against Aspen Road, it doesn't actually exist. Also, so the variance is to be able to come closer to that road, and I believe it was within, if I'm remembering correctly, within 20 feet of that line. And also, what I'm proposing is that the existing deck, I would like to add a screened area to the deck. You can see the house structure there at the bottom of the lot that is close to Aspen Road. The small rectangle that comes out of the house is the existing deck. The dotted line after that is the existing, or is the proposed extension, so that the existing deck section would actually be the screened-in area, and the dotted line would just be some extra space to put my grill, essentially. So that is what the request is, essentially. Is there any additional information that I can provide?
Well, let's see if the board members have any questions. Can I ask if we all got a chance to see it? I couldn't find it.
I could see it, but this helped me better. You wanna
Oh, thank
use
you.
a more clearer
I know the
map?
neighborhood, but I just couldn't
Yeah.
find the
There's a
entrance
picture
in the
of it. It's-
driveway,
It's all in wood.
even though your
In the
neighbor
woods.
told me how to do it. Yeah, and I think I saw it from one of the other streets. I saw your lights on, but I couldn't see the house.
Because Aspen runs the whole back.
Okay, anybody else have questions, board members?
And you own the property across
Yes,
Aspen
that's true.
Road?
I own the property, I own that lot as well.
Okay.
So
Which lot is that?
it is,
432.
thank you. I can't even read my own writing up here.
So the one right,
Yes.
so you went straight out the back door and walked.
So I'm on either side of Aspen Road,
Can I
yes.
see the file, please, Alan? Oh, I thought you had them in front
No,
of you.
this is just my files.
Did you buy both lots at the same time?
Yes.
Did you buy both lots at the same time from the original developer, Smadbeck, or from somebody before him?
I don't think it was the original person at all. I think there's been at least 3 owners, me being at least the third. I'm not sure if anyone came before that.
Do you know if those have been deeded together for some period of time? Like from Smadbeck?
Unfortunately, no, I don't know if any, before me,
You don't know that,
I don't
do
know,
you?
sorry.
Really?
Across from either side of Aspen.
Yeah.
Aspen still exists on paper, so the original developer owns it. Nothing is
Okay.
deeded on the owner's deed regarding Aspen.
Okay, so there is a Massachusetts statute that says, it's called the derelict fee statute. And the statute says, and you can correct me if you think I'm wrong, Kitty, but the statute says that if the developer deeds land on both sides of a paper street without retaining the fee in the street, which I know Smadbeck did, because he never retained the fee, that was the original developer, then the person who acquires those properties acquire to the far side, to both sides of the street. In fact, you own Aspen, but it's subject to the rights to pass and repass of anybody else who took deeds from the Smadbeck plans. If you didn't own both sides of the street, that derelict fee statute says you own to the midpoint, subject to the rights to pass and repass. Now, I believe that case law differs about whether or not the ownership allows you to call it frontage. In other words, your frontage is actually the midpoint of Aspen and not the sideline of Aspen, if you follow my logic. The case law clearly says you can't build on it because it's subject to the easement rights of others. But many cases have said you own to the midpoint, and therefore your frontage is really your front line is really the midpoint. That's the way this board has acted on decisions in the past, probably before most of your time. I don't know if you've been here.
Did this come into play in the Tehetawan Road thing that we did?
Yes, and the abutter erased somebody's rights based on that derelict
Okay.
fee statute. But I'm not sure we decided a Tehadawon Road one, but we've done others like that, where we've said the septic setback, for instance, to the sideline could be there, and the setbacks to the building sidelines could be there. So whether or not you have 30 feet if we go to the midpoint is still a question. Whether you own the whole thing is still a question. But I put that out there because it's a clear Massachusetts law that says that, and I think it sort of
She
favors
would own the
finding in your
midpoint
decision.
from
Yeah.
both parcels. So she essentially would own, under that, the
All of
whole,
Aspen.
all of that. Now, the other wrinkle is you said that you are trying to get your address changed to Birch.
If it works to eliminate that road, someone had mentioned to me that I could potentially petition to eliminate Aspen Road completely, since it hasn't been built, as far as I know, there's no plans to build it. That if I did that, then of course I'm also eliminating my actual address, so that I would then change it to Birch Road, which
It would be a
is,
rear property line issue rather than a front property line
Yes.
issue, which has different.
well, it wouldn't even be a property line issue, because if that didn't exist, I own both sides.
No, but even if you change, if we didn't even consider Aspen Road, under that scenario, there's different setback, there's a smaller setback for a rear property line than a front property line. So if your address was Birch Road without any other consideration of Aspen Road, when we granted you a variance, it would be, pretty small compared to the one for a front property line.
I get what she's asking, though. I think she's saying because she owns the piece behind it, but that's only if the two are combined. If not, it would still be property lines, and it would still be
No,
based
but
on
Jeff's
that.
saying it would be a rear property line.
Right, it would be 15 instead of,
At 30, yeah.
right.
So,
But it would still be a property line, even if she owns both properties.
Now, assuming this board wants to call it as a variance, what would be your hardship? Can you describe something unique? You said the property's unique in that it's a paper street, and it's unique in that it's wooded, and your neighbors on each side are woods. And what would be the hardship if the board decided not to allow it? Because you have to prove hardship for a variance.
The hardship would be not being able to replace the deck the way I wish to. There's the woods being there, obviously, it's a bit of a buggy area. If I could add a screened-in area, it would help me to enjoy the property that I already own. If I weren't allowed to do that, at the very least, I need to replace the deck. It's in a state that, it needs to be replaced. The boards are coming loose.
Perhaps the uniqueness and hardship of your property would be the fact that it's not a conforming lot. It's smaller than a normal conforming lot. The placement of your house on the property, how close it is to the property line, and the fact that these lots, it's obviously been put on what was originally 2 lots, that's better than maybe the need of a deck.
Okay, I didn't really know how to,
where is your
I
septic?
wasn't sure what you were asking
And
for.
where is your septic system?
It is it's towards the paper Washington Drive, so it goes to that side of the house.
Do we have any butters who wish to speak to this petition? We have the zoning enforcement officers here, but I believe they've written in. Do you want to speak or just read from the record? Do you want to read it, please?
I don't know where it is.
I'm not used to having you out there.
Okay, 61 Aspen
I
Road.
didn't know we were starting at 7:20.
The applicant seeks a variance from 173-31 regarding reduced setback. The applicant proposes to demolish the existing open deck and replace with a screened porch and open deck that would be less than the required 30 feet from the front property line. This is a unique situation whereby the address is a paper road and access to the home is from Birch Road. We like the uniqueness part of that because that allows us to consider a variance.
In an
No further
actual
comment.
fact,
Thank you.
in actual fact, since the access from Birch, that's like a side of the rear yard, a setback.
Right.
And that is 10 feet, so I wonder if they could reduce the
10
porch slightly to have a 10-foot from that line instead of 9.5. And then it would potentially conform at least to that requirement. Or is it 15 feet?
I think it's 15, the rear is 15.
It's 10 for
15.
the accessory dwelling, okay.
Okay, so I'll take a motion to close the hearing if you think we've heard everything.
I so move.
Second.
And then I will take 2 or 3 minutes to deliberate. I think we are going to stay on schedule if we do that.
All in favor?
Oh, sorry, second to close? I didn't
Yes,
get-
Alan
Okay,
seconded.
all in favor?
Aye.
And let's deliberate now. Does anybody want to speak to this? John, you want to start?
Well, so I think part of the issue here is if we assume that it's a backyard rather than a front yard issue, and since Aspen Road doesn't really exist, as you stated, the state regulations say that she basically owns to the middle of the street. She surely has 15-foot clearance to the middle. That I don't see if there's any reason why, if we use that as our criteria, that she should get permission to take it.
Thank you, Rod.
I don't really have any issue.
None. The only issue would be if you're the neighbor on Orchid Drive,
She owns a lot here, too.
you know, you're extending the deck.
She owns the other half.
Is if there's a possible objection, but, yeah, I think you actually, control everything around you, so that's no problem.
Alan?
I have no objection.
Okay, I'll take a motion.
I move we grant a variance at, what is the address?
61 Aspen Road.
61 Aspen Road for the construction of a deck within the setback
The road doesn't exist.
as shown on the plot plan prepared by Stampson McNary and dated October 4th, 2016.
No conditions.
No conditions.
Of 9.5 feet?
No.
You said per
Well,
plan.
I'm referring to the plot plan, it says 9.5 feet. Yeah.
I wonder if we just want to state the dimension, because
Okay.
people looking at the decision won't necessarily see the plan.
That's true. You sure about the measurement? We can say 9.5 feet?
The only reason we say that is you'll be held to that at 9.5 feet.
Yes, my contractor did the measurements, and
It includes the overhang, not just the,
You might want to say 9 feet.
I'm making 9 feet.
Make it 9 feet in case it's
thank you,
extremely-
Cheryl, for your assistance.
Shelley, you got some advice for us?
There's also a reduced side setback that needs to be included in that motion.
That's right. You're extending the, it would be 9.3, well, as, you're extending the line of the existing structure along that property line.
That was in the corner.
Yeah, thank you for calling that out. Do you want to amend your motion to include reduced side area?
Yes, I want to amend the motion to include, and I guess we have to refer to this as the front setback, even though it may not be. But anyway, for now, it's the front setback and the left side setback.
Can we use a north-south vector instead, please? North.
Okay. North, the north is the side, and the west would be the front.
Thank you. Anyone want to second whatever he said?
Second.
We got Rod seconding. All those in favor signify by saying aye.
Aye.
Opposed, none. Congratulations.
Thanks very much. Anything else I need to do?
As soon as the decision is recorded with the town clerk, there's a 21-day appeal period, and as soon as that's over, you can go and apply for a building permit.
Okay, and who do I give the fee for the
Oh,
posting
that
of
goes
it?
right to Jane.
Go to the beer fund.
Thanks very much, board, I appreciate it.
Yeah, we should always wait for the fee afterwards, so it doesn't look like she's paying for this.
Am I good to leave?
You're good to leave. Thank you for coming.
Thank you.
Okay, we're so far on schedule, Mr. Scott. 7:30 PM, I'm calling case number 909A. The petitioner Ernie Merrill requests a variance pursuant to section 17353, accessory uses for a proposed detached garage in excess of 30% of the floor area at 109 Mattawamkeag Trail. We'll let you present first.
Yeah, if it's okay, I'm just gonna, I typed up a letter that I'm passing, I'm just gonna read from that.
Sure.
Have you already given all of this material to the picture?
No.
Okay. Thank you.
Thank you for meeting with us. We are the owners of 109 Matawanaki Trail. We are asking for a variance to build a detached 40 by 30 garage. Due to the shape of our lot and the setback requirements from the property line, septic system, and the lake, the area proposed is the only option for the garage. The total square footage of our home is 4,742 square feet. The proposed garage will be a 40 by 30 footprint with one street level and a walkout basement level in the back for a total of 2,400 square feet. We have had the area staked out by an engineer, and the proposed area meets all the required setbacks. We will have pre-stressed concrete floors installed. The location will not impede on any neighbor's view of the lake, and there are already sheds in the area where we would like to put the garage. The street view will have 3 10 by 10 garage doors. The back side will be a walkout basement with 2 10 by 14 garage doors. The basement level will be used to store our boats on trailers, which is why the garage doors, we're requesting that they're being, for the height. We have provided photos of the proposed site of the garage, as well as samples of what the garage would look like. I've also added some letters from some of the abutters.
Okay, board members, any questions?
It's a very big garage.
We
First
did
off,
also.
you meet all the setbacks, why are you here?
The variance of the
Because of the
size.
size of the garage.
Okay. What,
In excess of 40 because of the first floor and
Through the chair,
oh, the
please.
house, thank you.
Thank you.
Does it have a second floor?
No,
Just, you know,
Main
just the
floor.
main floor and then
I
underneath.
just noticed you had dormer with it.
Well,
That was
just
just
the
the
view,
the
shape of
design,
garage,
yeah.
I got it. I went just like it.
Curb appeal.
Back to my questions to this year. Why so big?
To accommodate our boats underneath and our,
Vehicles up top.
we have 5 personal vehicles that are always at the home. So we would just like to be able to store everything indoors.
There's an existing 2-car on the house, and then the other 3-car would be for the other vehicles, so that everything would be able to be stored inside, and it's not parked in every which way, so it's not all in,
10 by 10 are big garage doors. Are you storing commercial equipment?
No.
I own an excavating company, but I have a shop that's in there.
Any other questions from the board?
I mean, I'd be willing to maybe go a little smaller on the
How are
front garage
we,
doors.
how are we considering the bottom level? Because it's partially below grade, does that impact the overall square footage in the way we consider it? Does our bylaw speak to
It's
that at all?
included. They included it. 40 by
Okay.
30 is 1,200 twice. So they said it's a 2,400.
But I guess my point is, it's essentially a basement. It's essentially a walkout basement.
Yes, but Jeff, we include the 40, in their 4,700 square foot house, that includes their basement also, so.
Okay,
You have, if you're going to include one, you have to include
okay,
the other.
that's a fair point.
Do I have anybody in the room who would like to speak to the petition? Mr.
I'm in a butter and they.
Please name and address for the record.
Dan Dupre, live at 51 Neshoba Trail,
Yeah?
and I've seen the plans, and I don't think it would have any negative impact. I think it would fit fine where it is, it would look great, so.
Can we get, is it possible to get the map up of all the abutters so we can identify who's weighed in?
And we did get a letter in today.
Yeah, I want to read the letter that came in today as well. Mr. Scott, I saw your hand up.
I'm in a butter to the right-hand side of them.
Name and address.
Peter Scott, 5 Scott Road. I'm in a butter, and by the design, if you look at from the street, you'll only see the one level. And to go out the basement back door, I think it'd be a great attribute to the neighborhood. And then if you remove 2 of the sheds that are a little bit unsightly, but other than that, I think it would be a terrific access to the property. I have no issue.
Has everyone had a chance to view the property?
Yes.
Okay, I would like to identify, oh, that's his plot plan, but you don't have the map. Anybody pull the map out of
Yeah.
I didn't have that one.
Matawanaki area?
No, the big one with all the, like, the room for us.
Let me try to get who's who then. As I face your house, is the house on the left one of these letters?
Ed and Marie, no, it is not.
And is the house on the right one of these letters?
one on the
Mr.
right
Scott lives next, owns the property next to us, and then the home to the right of that is one of the letters.
And then, so we have Mr. Scott on the right, we have the home next to that weighing in positively.
Sherry, Kitty has a copy too.
Thank you, yes, please. Across the street is someone who just spoke, or one of the letters?
He
So-
has, one of, his letter is in here, but he's also across the street. One of the other letters is two other people across the street.
Which, do you know which lots?
Yes, I have the addresses here. 51 Neshoba Trail, 105 Matawanaki Trail, 5 Indian Run, and 42 Neshoba Trail.
It's the same owner, that's what she was.
Is 5 Indian Run, is that Jack's, is it
Yes.
Jackson?
Yes.
Is he on the corner, or is he the next house?
He's the last house on Indian Run.
Yeah, so he's here.
And then he also owns 42 Neshoba Trail.
And where's Neshoba Trail? That's not touching you.
Can I see that from that?
And then, yeah, I'm just going to send it back in 1 second. And you're 109 Matawanaki?
Correct.
And so 105 would be this corner lot?
Correct.
That weighed in positively?
Yeah, and then
You
18
don't
Tadbrook,
abut
which is
one Indian Run, do you?
I'm sorry?
You don't abut one Indian Run?
No.
Okay, the next thing I want to ask is, when I went by it, it seems like you have a lot of toys, and they would be much more sightly interior to something.
Yes.
You also seem to have a lot of sheds that are in various states of repair or disrepair. Is it your proposal that all of those sheds will go away and all of the toys will be covered and inside?
We were gonna keep one of the tiny sheds because it has our kids' toys in it, but that one is actually in good shape, the other two aren't.
And on the right side of your property was some more toys covered with a tarp. Would those go inside?
Oh, no, that's the compost
Scott's?
pile.
There was a compost pile.
It's a
yeah.
compost
Okay,
pile
okay.
covered in a
Yeah,
tarp.
yeah, sorry.
Okay.
But the hope is to have everything indoors.
Yes.
And the other thing I wanted to ask is, I have trouble with this bylaw, and the building inspector's here. This bylaw says two things in the negative that really bother me. It says no more than 30%, and then it says no more than 50% of the land area. So first of all, by eyeballing it, this is not more than 50% of the land area, is that right? Then it goes on to say, customary home occupations are allowed, except that if they are in excess of those two figures with the or in between them, then they're not customary home occupations. So if they're not customary home occupations over the 30% limit, what are they? Principal uses? Do you need to see the bylaw to
I would
answer?
like to see it, yeah.
Yeah. It confuses me every time I read it, frankly.
So back in the mid-90s, I sent you a letter regarding that, and I asked for your opinion, and we came up with an agreement as to how we would handle this. So this is how we handle it. If you're willing to change it, I'm willing to change it also.
I sort of like the idea that it has to come here so we can get the neighbors to weigh in. But I am reminded of a case many moons ago when I first sat on this board where we denied the applicant, and he just ended up building two sheds, two
Correct.
big barns side by side.
Correct.
And he got around us that way. I don't remember who that was offhand, but,
All right.
but I don't think the bylaw says that can't happen.
It can happen, and that's why that individual did that.
Yeah.
It's unfortunate, and again, I came to this board to ask for some clarification, and we arrived at this conclusion.
Yeah.
And I can resurrect that document because I kept it.
So tell me again, if it says no more than, does everyone have it, does anyone have it in front of them? It says,
Accessory uses,
Yeah.
to me, is a separate and independent from home occupation. I don't think they're
Yeah,
together.
it doesn't affect that.
No.
They're not suggesting they're putting a
It's
home
not a
occupation in there.
We're just looking at accessory uses. So you're allowed 30% of the floor area or 50% of the land area.
So-
Now, my question to you at the time was 50% of what floor, 30% of what floor area?
Right.
And the conclusion was, well, it must be the primary use of the property, or the principal use of the property, which in this case is the home.
Right, but the home would include garage and
Correct.
basement
Well,
and...
and again, I came up with what that included. Everything but attics, porches, everything else I
Decks.
believe was included, and decks, correct.
And I'm still stumped because it's not an accessory use in the sense that maybe a Reiki studio on the lot is an accessory use or a home occupation. It's
Well, it's a storage
It's a
facility.
storage,
It's an
it's not a
accessory.
storage facility, it's
It
another
is a
garage.
storage.
It's a-
It
it's
is a
another
storage
garage.
facility, whether they're storing cars in it or not. They have a primary garage. This is a storage facility for their extra vehicles and their toys. And, you know, I think that that's okay. We just have to look at, is it going to affect the neighbors adversely? Is it a problem with views or setbacks? Are they going to, are they building a potential for an use that would be negative to the
Or
community?
prohibited, yeah.
Or prohibited to the neighborhood? What do you plan, this is a beautiful building, but what do you plan to put on the second floor?
Nothing.
Just like the look of that is why we did that.
I think it's a dormer, it's like a front dormer, it's not really,
Yes.
well, maybe.
You pulled something off.
It's something
Yeah, we put it
offline, yeah, it's
offline,
just an
'cause we didn't
idea
have
of
it-
what.
So I had, just had the
And
plot
we,
plan done, I didn't have the
actually, we
actual
appreciate
design.
some image, but we shouldn't take that image as...
No, it may look a little bit different, we wanted some sort of picture of what it would look like.
And before I go too far afield, I'm sorry, we did have a negative letter come in, and it should be read in the record today. Do you have a copy of it? I have it.
There's no second floor.
Is it a flooring? Storage space.
That's a beautiful picture. I like it too.
Okay, to the zoning board. We are writing to express concerns about the 40 by 30 structure proposed for 109 Mattawanakie Trail. Any large changes to the area bordering the lake, physical and visual, are of importance to those of us living in the area. When a lake abutter enlarges his property by filling in a portion of the lake, adding to the total property of 109 Mattawanakie Trail, it concerns those of us who care a great deal about the lake and its health and preservation. Similarly, a lake abutter adding a 40 by 30-foot structure, height unknown, to a property with an existing large house would result in a total developed property disproportionate to properties in the surrounding area. In addition, the proposed structure hardly matches the definition of a garage, since at 2,400 square feet, it may more closely resemble a warehouse. It is also unlikely it would not impact views of the lake. This is a residential area with many houses that were once cottages, and perhaps you could take some time to come and take a look to judge for yourselves whether this proposed structure would be out of scale with the neighborhood, as well as being an inappropriate building for this area. Thank you for your attention. I also want to ask one more question, and that is, which direction is the 30 by 40 going? The 40 is going to be the breadth of it, and
This
30
is
is
40 wide and 30 deep.
Could you consider, instead of industrial height, 10-foot doors that are normal, what are they normally, 7 or 8 feet?
If we could, well, the one thing I would like to put in there is my pickup truck, and the pickup truck, I mean, I would probably do would 9 foot high and 10 wide be?
I just...
Or are you saying 10 wide's
just-
too
just-
wide?
Just, I'm trying to get you to a normal garage door so that this doesn't look like a warehouse.
No, I understand. I'm just saying, I guess the car side of it's fine, it's just my truck is,
Well, you gotta-
8 foot
I
6
understand.
wide
You
is
gotta
the
put-
only,
you
the
wanna
only.
10 wide is perfectly fine.
Just when you
It's
get
just the
that...
height is
The
the,
height.
yeah, I mean, I could measure my truck, but 9 high should be plenty
Well,
fine.
8 foot's probably plenty.
Yeah, it probably is.
So then your normal garage
Yeah,
door
that's fine.
height, and you don't look like you're putting in...
Yeah, no, I understand.
It also knocks a couple feet out of the overall height of the building.
True.
Yes.
Bring it down a little.
Mr. Scott again?
I have 7.6 on mine, and my truck is the same size as his, and it does just barely fit, so an 8 foot high by 10 foot wide would be great, because I have the exact same thing in the residential, it looks great.
Do you have a
So
good one?
He could drop it down to 8 by 10 and fit with the mirrors, and it's a tight fit, but I think that would be very nice, and if you wanted to, put maybe a transom above the door, so it even looks much more appealing from the street. Can I ask who sent that letter, the opposing?
Oh, did I not read it? I'm sorry, I should have identified the writer. No, I don't know where I just put it. Sorry. It was written by Pam and Tim Hayes, 77 Mattawanaki. I apologize, I didn't do that on purpose.
So they're not
They're not abutters, they're on the other side of the neighborhood, just for,
around the
Just for
corner,
fact.
basically.
I don't, yeah, like, down.
It took me a while to drive down to their house from their house.
It's a hard neighborhood
Yeah,
because,
but it's still lake views are being affected,
Right.
don't you think?
and people walking
Yeah.
and areas. It's a tough neighborhood because a lot of these old cottages are being torn down, rebuilt, much bigger houses are being built. And it causes some tension between people who live in small cottages and like it looking like a lake area as opposed to people who want big modern colonials that have waterfront. It's tough, but on the other hand,
I'd be curious, have you talked with your neighbors on the left?
Yes.
Yes, they did, we just didn't
Brought
cross
them
them.
along and they're.
Yeah,
Yeah, they're-
Because they're going to be the most affected.
Yeah, I agree.
Not in the principal view, but in their house.
Because it's
probably
right next to it,
Three of
yeah.
them could fit in this structure, so.
Yeah. no,
We've talked with them since we just bought the house 3 or 4 years ago, and they've been very nice.
Yeah, they
They're,
just
you know,
kinda keep
we've,
themselves
anything that we've, you know, done to, you know, we had the house painted, did some, you know, upkeep and stuff, and they support us. We didn't get to reach out to them to get a
He
letter.
works nights a lot, and she does as well, so.
Anybody else? Yes.
Just one more comment. If they were two attached to the house, let's say, they wouldn't be here today.
Right. This is only because it's an accessory structure.
Did we read the building inspector comments?
Yes.
Yes, okay. I'll take a motion to close the hearing. I think we've discussed it enough.
Move to close the hearing.
can I ask one more question before we do that?
Sure.
Why 40 feet wide?
3 garage doors wide, and then the boat, just to be able to fit boats and stuff in there. So it was 3 cars wide.
It's got lawn equipment, jet skis, there's a whole bunch of stuff in there.
A basic 3-car garage is 36 feet wide. This isn't really much
Bigger than that.
bigger than that. The depth is bigger, but the.
It is, but
width
the depth we need, because the boats, to put them in the garage, they gotta be on the trailers.
Keep it low as you can, so that, because you're on the downhill side.
Yeah.
So if you keep it as low as you can, then you're going to be much less.
We're setting
egregious.
it like into the hill, so it will
Yeah,
be.
I know.
And again, that photo was just, we just went online, and that's
Oh, it's
just,
a beautiful garage.
that's what, yeah, it was just, we saw the photo, and we knew that that's what we wanted it to look like.
Okay, I have a motion to close the hearing. Do I have a second?
Second.
Second from Rod. All those in favor?
Aye.
Opposed? None? Any discussion, or does someone want to make a motion?
I have a question for you. What were you trying to get at the first, when you were first? Were
I
you
don't
trying
like this
to-
bylaw. I just, every time we have something
Were
come
you
up on
trying
it.
to say that this shouldn't even be subject to a variance?
No.
Okay.
No, the bylaw is here so that, exactly this, so that people have to come before us. And I think we're in 26B, so I think it's a special permit, not a variance.
Yeah, it doesn't seem like it should be a variance.
It's a special permit, but the reason it's here is because it was felt when it was drafted, like, it's 26B, accessory uses. 26B says,
Let me pull it up.
accessory uses B.
It's uses, though.
No accessory dwelling. Not accessory scientific, so why is it under 26B?
It's not so bad here.
You see, this is the whole reason why it bothers me. It says, customary accessory uses are permitted. Our definition of accessory uses says,
But we're not here to talk about the use of it.
No, we're just talking about the
of it.
size.
Hang on. Accessory building or use. A building not attached to any principal building, that's what this is, or a use customarily incidental to and located on the same lot with the principal building. Well, a use is a storage building for your principal uses. That's what you're calling it. So he is an accessory use. They are an accessory use, and they are also an accessory building. But the bylaw says, customary accessory uses, and I would call garage storage for your toys a customary accessory use to your principal dwelling, are permitted as specified in 17326B. Well, there's nothing in 17326B about storage for your stuff. But then it says, it's not considered accessory if it's more than 30% of the floor area. So he's more than 30% of the floor area, so he's no longer considered accessory.
What is
Excuse
it
me, I keep saying
considered
he,
as?
I mean they. It was in your name, that's why I'm
That's
doing
fine.
that. But it says, not accessory if they occupy more than 30% of the floor area or more than 50% of the land area. Well, it's more than 30% of the floor area, but it is not more than 50% of the land area. And since that's an or, I would interpret that to mean they're okay, they're not considered.
No, it's an and/or, it's not just an or.
No, you
It's not
can't do
or in
that.
that way. It's.
Do you have it in front of you?
I'm pulling it up right now.
Can
What page are
you
on?
read his and tell me if you, I mean, the way legal structure of statutory language is interpreted, if they meant it to be and/or, it needed to say and/or. If it says or, it's or.
Yeah, so if either of these two conditions are not met, then it's not an accessory use.
So
that's
it
the
sends you
way-
back to what is it, if it's not an accessory
Exactly,
use?
yeah.
And then I would say, it's not a principal, it could be called a principal use, a second principal structure on the same lot, but I don't think that's what the bylaw meant for us to do.
But I think that's what's happening. That's where you're getting stuck, is once you go over the 30%, it now becomes another principal use of the property. So they're asking for a variance from that.
Except I maintain that the over 30% maybe sends them to the principal use, but the fact that they're not over 50% of the land area,
But I don't care about 50% of the land area. I understand what you're saying. You think it's inclusive, 30%, 50% or nothing, and I'm saying they can stand independently.
either one. If they exceed either one, they go back to principal use and they need a variance, is what you're saying. And I'm okay
I agree with
deciding
his
that.
interpretation.
But in all fairness, I struggled with this years ago, and I came here to clarify so that it'd be fair and balanced to everybody, because that's how I treat everybody.
And
Do you have the letter that clarifies it? Could we
Yes, I do.
stick that in as, not today, but so we have it in the
Yep.
future? Because I struggle with this every time it comes up.
I do, I have it.
I'd love to see it.
And special permit versus variance, I guess further down in the article, they do specify, now, if you did scientific experiments in this building, apparently you could get a special permit.
We do have 2 young children, so.
And the experiment of getting that truck in there with an 8-foot height is going to be a scientific problem.
But since it doesn't specifically say that under this first thing, I think you're right, it should be a variance.
But if we
Most
say
trucks aren't
variance-
higher than 7 feet.
What's that?
Most trucks aren't higher than 7 feet.
I don't know what the whole, I mean, the only thing that comes to mind is parking garages, know how they say, like, don't go in, you know.
Rack on top.
Yeah, that's going to be a problem, yeah, that's going to be.
8 feet is
It will fit in an
customary.
8-foot door. You'll be fine.
One more, just one more thought on this. You said that there's some letter that interprets this 30%, 50%. Maybe at the same time, we should consider whether or not, as Jeff argues, a basement is included in the accessory use calculation because,
Yes.
well, you said it is because we include that in the overall house calculation. But if
If
you're,
you're going to do one, you got to do the other. I
do.
argue with you on that one.
But if you took the house, what if you took the house basement out, would you meet the,
oh, there's a good question.
No, but in this case,
He could be right.
Take both
If you
basements
take
out?
the basement, both basements out, he might be over
but a
30%.
normal garage would not have a basement.
no.
right.
So in
Yeah,
this
that's
case,
right.
the variance arises because it's on a sloped, it's a unique
Yeah.
site,
All right,
and it's
folks,
on a
we're-
slope, and you're able to.
We're off schedule drastically.
No, I don't care, everybody's entitled to their time. Okay. I think they're academic questions of interest, so.
We've
We are
closed.
at the point, we've closed and we've discussed. Anybody want to make a motion?
I mangled the last one, so.
Maria, do you want to try it?
You want me to try?
Sure.
Yeah, that sounds good.
All right.
I'm struggling a little bit with it.
And I gotta find his application. And I buried it.
Yeah, the other thing is, they're talking about 50% coverage of the lodge. I was thinking 30% coverage versus 30% coverage of the main dwelling, as opposed to living, total square footage within the dwelling.
No, it's square footage within the dwelling, the floor area.
And they can,
But I'm still looking at this is more aimed at lot coverage as opposed to, the physical size of compared to the residence, but I
does
didn't write it.
does your 30 by 40 include your roof overhangs?
It's not,
I don't know if
it doesn't have to be
we-
a side lot, so that doesn't matter, it's just the square footage of the building. Through the chair.
Thank you.
Yeah, since.
Okay.
Designed the actual
You're looking at
The
your
variance is
15
for the
feet.
square footage. You're
footprint,
going to
yeah.
locate it
15
within.
and a
Yeah,
half.
we don't have any issues with setbacks on the.
But you're
property line.
15 and a half feet on the left side. I
No,
think
he's all right on setbacks.
But they're not requesting variance for
Okay.
setbacks.
All right, so I make a motion that we grant the special permit.
No, it's a variance, Roland.
Is it a
convinced me.
variance?
Yep.
I thought you said it was a special
No,
permit.
Roland changed my mind.
This is why none of us want to make motions. I make a motion that we grant the variance as requested at 109 Manawanaki Trail, and more specifically, as shown in the attached plan for an accessory dwelling,
No, for a 40 by 30 garage. Or accessory structure, not dwelling.
accessory structure of 30 by 40. Do I say anything else?
That
I'd like to
exceeds
add
the
some
30%.
conditions.
Yeah.
Add some conditions?
I'd
Refer
like
to the
add
square
some
footage.
conditions.
Yeah, it should say the variance for exceeding 30% of the square footage of the main dwelling.
I'd like to add conditions
that.
that the garage doors be no greater than 8 feet by 10 feet.
The front side garage doors.
Front-facing garage doors, right?
Yeah, because it needs the taller ones in the back, otherwise it'll get us
Okay.
on trailer.
I'd also like to make a condition that the existing 2 sheds be removed
Absolutely.
and not replaced forward of the garage, even if it's the kids' toy shed.
Any others?
Well, you didn't want a second story, and you don't want second-story occupancy?
No second-story occupancy.
Well, if they
But
build
if
a
they come back
structure
to
and
us-
they want to, they'd have to get a further, another variance.
They'd have to go to the Board of
Well-
Health for,
This is a tricky one.
But it could be second story.
Because now is it
Story.
considered
Now,
part
now
of the?
now the square footage is greater.
What if we go with a height?
Just say no second story usage.
Yeah,
Well,
So if
I don't
they put
care if
standard trusses in, there'll be no way to get up to the second floor.
yeah, because you don't want storage
I don't-
up there.
do we not want storage up there? Why
No,
not?
because then it might make it taller to make room for storage.
No, it's not going to be a
I don't
dwelling, he
care if
can't
it's
do
That's what I'm
that.
saying,
Yeah, he
that's the
can't do
issue,
that
so-
without permits, but
so-
what I'm worried about is that the height not get high enough
Right.
to obscure views after the neighbors all said they saw the plan and they liked the plan. So I'm just trying to restrict the height, not to have a full second story on it. I don't care if there's no trusses, I don't
Just
care
wanted
if
to
it's
make it
storage.
look nice with the
Yeah.
roof pitch and, like I
Yeah.
said, that front dormer and stuff.
They need a safe,
The issue is that with a 30-foot depth, if you did a conventional roof, you would have a very high ridge line. And so I think it's the board's feeling that you need to do whatever you can to reduce the overall height. You could put a number on it.
building not to be higher than
No,
total
not
building?
magic pitch. But
Yeah, the pitch is what I think we need to address.
No longer than higher than 6
Mr.
or 7.
Scott, you want to help us with the pitch?
Well, if it's 30 feet wide and you go a 12 pitch, which is a very steep roof, you'd only be 15 feet higher than the top of the first floor ceiling.
But I don't think we want to go that high.
So, correct, so I think not to exceed a 9 pitch would be more than, it's like 112 inches or something like that.
Like 10 feet.
You okay with
Which is
it?
very reasonable for a pitch, and it'll look nice because his existing house is a 9 pitch.
Not to exceed 9 pitch, you're
Well,
okay
then
with that?
that's an
9
existing
inches
house.
is what-
Can you go less than that and still get snow shedding?
Oh, yeah.
Squatty when you do that. I think
You go
a
flat.
9 would be good.
Yeah, I'm happy with that. I just didn't want it to be a big, huge, high, pointy pitch.
No, I mean, I don't want to make the thing look
Okay.
gaudy.
You can make it
anyways.
less
I mean,
than
we're
that.
trying to make it look proportionate a lot, too.
Okay, do you want me to repeat the motion? Cheryl's motion is grant a variance for 40 by 30 accessory structure on the property exceeding the 30% of the gross floor area, with the conditions that the front-facing garage doors will
Be no greater than.
no greater than 8 feet by 10 feet, that the
Why don't you
existing...
do 10, usually it's expressed 10 foot, I mean the width and height, so do 10 foot by 8 feet high.
She just said that.
No,
No,
it's
no,
going to
no,
go the
no,
other
I'm
way,
flipping
because
them.
he's the architect, yeah.
Oh.
And specify which is
And-
which.
And the existing sheds be removed and not, and no sheds forward of the garage. And
All 3 of the sheds, or just?
he wants 2 removed. I know the third one
The
was,
third one's
and
tiny.
it was kind of pushed over where you couldn't see it.
I may get rid of it as well.
Yeah.
so.
And then,
You should have plenty of storage inside.
and that the roof,
Pitch not to exceed the pitch of the existing house?
Yeah, that sounds reasonable.
you like that?
Yeah, I think this is a
Okay.
difficult discussion to.
Okay. Pitch not to exceed that of the existing dwelling, okay?
Do you guys like how I wrote this motion?
Good job.
Can we have a second to Cheryl's motion?
Second.
Notice how she keeps saying Cheryl's motion? She can't.
Second by Ellen. All those in favor, we're getting silly. Did it start snowing yet? All those in favor signify by saying aye.
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 Opposed?
You're good.
Good luck. Yep. It's a variance, you have to wait for the appeals period, and then you can apply for a building permit.
Okay, thank you.
Okay,
21 days?
yep. Can I have a show of hands, how many people are here for 563 King Street? Can I ask you if you've all signed into the sign-in sheet in the rear of the room? Please do if you haven't done so yet. I'm also going to exercise a board chairman's prerogative to take the next 2 out of order.
Good. Need snow. Getting dry out there.
It's getting dry out there. What?
No, I'm not doing King Street next, I'm going to take it out of order. I have a 7:50 hearing for Loxley Road. I happen to know that the Loxley Road is probably going to be a short hearing, and the 740 case has got a lot of people in the room, it's going to be a long hearing. So if you could be quiet in the rear, I'm going to take the last case in ahead of you, and then I will have plenty of time for your case. So you want to come forward, Mr. Harulis, and tell me your position. This is 7:50 I'm calling the 7:50 PM case 894A. The petitioner, Anthony Harulis, requests a modification of a variance pursuant to Section 173-10B, nonconforming uses and structures, and Section 173-31, intensity of use schedule, for a proposed landing and steps with a reduced street setback at 11 Loxley Road. Go ahead.
You have your thing up here. Okay, keep over your shoulder and copies.
Anthony Harulis, we needed to adjust the front landing because we changed the grade in the front of the house. We're asking to be able to put a little landing there so that I can add potentially later, if need be, a small motorized lift for my dad's wheelchair to be able to go up because we can't dock it to the stairs. So that's the reason for the little landing to the right. And this was an oversight when we originally came about 6 to 9 months ago.
I don't know where you want the landing.
To the right of the stairs, see?
It's on the,
Right there.
Oh, this
Little
one.
tiny landing.
yeah, so originally
not
there was,
teeny.
the diagram shows it out front,
So he's saying that they want to make a landing like that.
I swear it was different on
So this little piece right here, see it?
that little one. Okay.
So you're saying it's 6 by 14, 6 out from the house and 14 wide?
And that's to accommodate a wheelchair lift?
It's so that we can have the ability to roll him straight out the front door, and he can then take a turn, and we can put motorized, it goes straight up and down. And so also so he can go outside, because everywhere else will require stairs.
And that 20 feet to the steps, it was on the original plan,
Yes, sir.
and this is inside that. Okay.
Yes, sir. Basically, there was a little pad there before. We're reworking the stairs, so we took the pad out. It's noted on the diagram, and we're just basically turning that right from the stairs instead. So that's under the overhang also that's there, so that he doesn't get rained on as well.
Make a motion to close the hearing.
I would like to ask if the board has any questions first.
That's my question.
Is there anybody who's in a butter who has anything to say about this? And I would like to ask why this isn't construed to be handicap access, which zoning is not allowed to regulate. So can I hear from the building department?
Yeah, when we originally received this application to modify the building, we struggled with the handicap ramp and the landing, and that would have been fine. We had no problem with that because Mass General Law allows that. Whereas the deck appeared to be much larger than what was needed for handicap ramp, and since you had already granted a special permit for the addition, we felt as though that it would be nice if they came and modified their special permit. But this evening, I'm hearing that now you're talking about a lift, and I didn't know about that.
It's, if I may, it was after the fact.
Okay, no, I don't have no
It's-
problem.
It's literally, it's not much bigger than this table, and it abuts, you need a flat surface so that it goes straight up and down. It's got a little thing on it, so we can.
Yeah, I know how they work, and
Okay.
I guess the initial conversation with the contractor, I misunderstood.
So.
No, I think not at all, because Shelley and I went back and forth to get messages to Mr. Hurlis that I felt that it wouldn't have to come here if it was a handicap ramp or handicap access, and I think he verified to Shelley that they had no intention of putting a ramp on it, and this is an afterthought. So, I do want to clarify for the board, however, that a landing like this for the express purpose of having handicap accessibility is not a matter which zoning can regulate. And so putting the lift on it that way makes it handicap accessibility only, and we have no right to say no to it.
Yeah. And is
Do
this?
we want to grant it just so there's no questions and since he's here?
Sure.
And we're
is the
collecting his
lift-
money?
Is the lift definitely going in?
I haven't
Is he
determined
gonna
that
be-
positively yet. He's still somewhat mobile without the wheelchair, but we prefer the wheelchair so he doesn't fall. And it's more than likely not until springtime we'll make that final decision.
So if the lift was going in, I'd say
Immediately.
it was under handicap, but if not,
Yeah.
we could amend the.
And that's how the building department handled it in asking him to come here. So I will now accept a motion to close the hearing.
I make a motion to close the hearing.
Second.
And all those in favor? Aye.
Since I did such a great job with the last motion, would you like me to make another one?
Sure.
I make a motion. If you give me the right,
Why don't you go right to the agenda and read it right after?
I make a motion that we grant the modification of the variance pursuant to section 17310B for non-conforming uses and structures, intensity of use for the proposed landing and steps with reduced setback at 11 Loxley Road, as shown on the plan, as drawn on the plan that says number 894A modification.
Second?
Second.
All those in favor?
Aye.
Opposed? Granted. You're welcome. And one more hearing that I just want to see what we've got in the room for it. Is anybody here on the 15 Great Road?
I told them they didn't have to come because they showed it on the pictures, so it was figured just.
Oh, make the determination. Okay, so we can do that at the...
They're not
oh,
changing the
we can do
size.
that at the end of the hearing. Okay, fine. So now I'm going to call case, this is The 7:40 PM case number 910A, thank you everyone for your indulgence. The petitioner, Joseph Cataldo, requested appeal of a decision of the Zoning Enforcement Office pursuant to MGLA 40A, Section 15, and Littleton zoning bylaw, Section 17326 use regulations, and Section 17378 noise for property located at 563 King Street. This is the building inspector's determination, so maybe you can begin by giving us an outline.
Want me to read this?
Oh, I'm sorry, it's an appeal. I apologize. It's an appeal. Attorney, will you identify yourself?
Good evening, board members. Excuse me, Joe Cataldo, my attorney, Chris Worthy from Bowick and Brooks.
Bullwinkle and Brooks, yeah. Chris Worthy here on behalf of Mr. Cataldo.
Thank you for your time tonight.
Go ahead.
So we are here to appeal the decision that was issued by the building department regarding several matters that take place on the property, including the use of equipment on the property, the use of trucks on the property, several other concerns that they had about how the property is being used. The response that I submitted in the appeal application, I think, addresses most, if not all, of the concerns that were raised. I believe that all of the concerns have been taken care of, some of them eliminated, at least one of the concerns being the trucks that are used on the property is allowed as of right under both the bylaw and state statute. I'm not sure if there's specific place that you wanted to start with, a specific issue that you wanted to start with.
Well, let's try to identify the building inspector's order and what are the components of that, and let's take it one component at a time, please.
Sounds good to me.
So I need to get to the building inspector's determination. And it was, I think, September 25th, 2018, if I'm not mistaken.
That is correct.
And I saw that it said, on page 2 at the bottom, since a September 7th deadline passed, you're ordered to cease and desist the operation of the landscaping business. So that would be one order to cease and desist, am I right?
Correct.
The second one says, regulation of noise within the town of Littleton. Is that the second one?
That's correct.
And I thought the third one might be hours of operation. Am I right about that?
I think that is combined with the noise.
Okay.
Because the concern, I believe, was noise, the noise level before 7 a.m.
Okay.
I'm not sure if it's a completely separate issue or more like 2A to the noise issue.
Okay. And is there a third?
I believe that should be everything.
Okay. Now, for those of you who weren't in the room when I announced how we handle this, I'm going to let the applicant speak until he's exhausted his arguments. And then the board is going to ask questions. Then we're going to open it up to the building inspector. And then we're going, who's defending his decision. And then we're going to open it up to abutters. And everybody will take turns, and we'll have all the time you need, because I got rid of all the cases behind you, okay? So start with your arguments on the landscape business, please.
So on the landscaping business, first of all, this family has operated this business here for close to 40 years now. They have, over time, come before this board on several occasions, have been to either grant additional permissions of how to use the property or to seek clarification of what they're allowed to do. Each time it has been friendly, trying to work with the board to make sure they're doing the right thing, to make sure they're operating the correct way. Back in 1988, there was a special permit that was issued to allow the farm stand. Well, so first of all, the farm stand there is allowed as of right, as a agricultural use. under the bylaw and under state statute. And that use of the property was expanded under a special permit. There was a subsequent decision saying, again, confirming that the use of the property as a nursery and as a farm stand is allowed as of right. Over time, the business obviously has grown, has gotten much more complex. Instead of beyond simply selling flowers and plants there, they also have contracted with their customers to install those items, those horticultural items, agricultural items. And between the own decisions of this board and state law, and specifically Chapter 40A, Section 3, regulating agricultural uses, between that and other cases that have come down from the land court and the Court of Appeals, that any use of what's, I guess, considered landscaping to deliver to customers and install at customers' properties, those product that were sold from the nursery are allowed as an accessory use, allowed as of right. And as this business has grown, the Cataldo family created the M.J. Cataldo Landscaping primarily to act as an agent for the nursery to carry out the allowed uses on the property. As the M.J. Cataldo business has grown, they have realized that they need more space, which is why they have since purchased property in Ayer to operate a more, what you would call a contract landscaping. What remains on this property in Littleton is the operations, the trucks, the accessory uses, what is necessary to carry out the business of the nursery. And we believe that anything regarding landscaping has been addressed, that if there were what has been described as a general contract in landscaping, they have sought to move that off this property, and that the landscaping uses that are continuing to run there are strictly or are primarily for the use of the nursery as a necessary and integral part of the operation of the nursery. So I believe that is how the landscaping part of it has been addressed. As for the noises, there were a couple of different allegations of noise that were addressed in the decision by the building department. First one was a sand or a screening machinery and a loader. Those were concerned. The Cataldos have sought to move as fast as they could to end that operation, acknowledging that it was not a great idea to have there. They have removed that. It will not return. The loader that was there that was also too loud was an older, what was it, a 1994 John Deere, and they have replaced it with a newer and much quieter loader, which is used for the nursery to move product around when it's delivered, when it's being shipped out. There's a lot of dirt and other materials that are necessary to operate the nursery. They have addressed that noise complaint by removing the noisy equipment. What's remaining there is no longer, we believe, too loud. Finally, the trucks that are operating, again, are operating there. They are trucks that are owned by M.J. Cataldo, but as part of the same family business, their operation is to support and be used for the nursery to deliver new product, bring in new product, to deliver it out to customers that have purchased whatever they have purchased at the nursery to be installed. And that the trucks that are there are a proper use of the of the vehicles, and also allowed, specifically noise-wise, because they are registered motor vehicles and are exempt under the bylaw. That's basically the extent of it. They travel up and down Robinson Road to get to and from the property, traveling over Farmstead Road, sorry, Robinson's the other side, Farmstead Road, thank you, to get to and from the property from King Street, and are registered vehicles that are, their noise level is governed by their registration and exempt under the bylaw. Or I forget, anything else you need to add? I think that is the main point of what we see the issues are and how my client has worked as hard as possible to try to make everybody happy to comply with the concerns of the building department now and over several years in the past. Anytime an issue has been brought up, they have done whatever they can to try to fix it and try to be good neighbors.
Board, any questions on the
Have you
presentation?
had any complaints from any other neighbors?
Directed to you, have there been other complaints?
No.
I believe some may have been addressed to the building department, but not directly to.
Before we get to that spot, I would like to hear from the building inspector, and then we can ask about
I have one
what
question.
brought his
Well,
attention to the property, Cheryl, so let's wait.
Pulling up the assessor's map and trying to figure out where exactly where this.
It's right next to it.
We haven't yet gotten to the place where we even know who the complainant is or why, so let's wait and take this in an orderly fashion, please.
Yes, dear.
Thank you.
Was the nature of the noise complaints the noise level or the hours of the noise?
I believe it was both.
Okay.
And I believe that both of those have been addressed. One by the noise level has been the removal of that, the sifter and the old loader. And the hours of operation, while they have tried to limit it, the only pieces of equipment that are operating on before 7 a.m. are the trucks that I believe are exempt from the bylaws.
The next question is, I would like to hear from the building inspector now, you having stated your case. Do you want to trade and come forward, or do you want to do it from there? Did the cease and desist come from you? Yeah, so let's hear from the assistant building inspector.
Zoning officer.
Zoning officer. Thank you.
Okay, so I put our chronology of how long this has been going on. It's pretty well outlined in the letter. We started receiving the complaints about a year ago and were in contact with Mr. Cataldo. And he's been very cooperative in addressing concerns as they've come up, and he advised us that he was looking for another property to move the landscaping portion of the business to. And so, throughout the course of the past year, it was sort of on and off that we were receiving the complaints. So, we just told him to try to just keep the noise within the 7 to 7 time frame, and the sifting of the soil that had stopped, and they moved that piece of machinery over to his new property in Ayer. He had given us a timeline of when he was going to be moving the business, and that he had to go through the planning board in Ayer, and then he was held up because he needed to get a National Grid permit because part of that property lies under power lines. So he was delayed again on that. But during that time frame, he had given us the 120 days, which, we were sort of holding him to, and he did advise us on September 7th, which was the end of the 120 days, that he still was waiting for the National Grid permit. But right after that, we received some more complaints about the noise, so at that point, we just felt like we had to give him a formal letter because he had exceeded the timeline.
So I have a couple of questions for you. You had a 120-day, your office imposed on a deadline for him to do what?
To move the landscaping portion of the business.
And what do you describe as the landscaping portion of the business?
I guess we'll just call it the white Cataldo trucks that,
If I can answer that, it's the portion of the business not in connection with this transplanting of nursery stock, which comes from the verbiage out of your, was that a special permit?
Are you talking about the 88 one?
Yes.
Or the original
87.
one?
And so there's no argument in the building department that Mr. Cataldo's nursery business does do transplanting of nursery stock, but it's not exclusive to that. If you read my memo to the board, I think we made it fairly clear that it's not exclusive to just that. There is a commercial landscaping business, which I don't have a problem with, except that this board here made it clear that you didn't want that to happen on the site. With regards to sifting of dirt, I personally don't have a problem with sifting of dirt. Mr. Cataldo can sell dirt. We have other entities in town that sift and sell dirt. To me, there's nothing more agricultural than selling dirt. But when we look at the cease and desist, and maybe it was a little awkward in explaining in the letter, we gave you a chronology of events, and then we said the commercial landscaping business, not in connection with the transplanting of the nursery stock, just can't happen. The second part of that is, because of that, there's noise, and we want the noise to be reduced to the levels that are approved in a residential area. We have no intention of controlling residential vehicles, registered motor vehicles. It's just not our job.
May I ask a question, Chair?
Yes.
In my experience with farms, which is fairly extensive since I have a whole bunch of Iowa relatives, tractors and large trucks are part of farming equipment and frequently start before 7 a.m., start with a sunrise, especially on days when sun sets at 4:30. So you're not, a loom sifter to me, a screener, would be integral to farming equipment and would be farming equipment or nursery equipment. What you're talking about is like trailers with lawnmowers on them that go out and do landscaping equipment? Where are you differentiating?
A commercial landscaping business that's, and again, it's within the verbiage of your special permit, not in connection with the transplanting of nursery stock. Or everything else is
So
a
what does he have that is that?
landscaping business.
Can I?
I guess I need, what is landscaping business?
Look, and let's just be clear, since we discussed this with Mr. Cataldo, we didn't kick him out of town. Mr. Cataldo offered to go purchase other property, which I thought it would have been a nice solution. I don't like to see Mr. Cataldo leave town, but that's a solution that we can live with.
Well, then I'm not trying to put you on the spot, I'm just trying to understand. Are we talking about trailers with equipment to go landscape other people's
I
yards?
don't know what he's got in his truck. All I'm saying is, you said that if it's not transplanting nursery stock, you can't have it here.
Can we calm this down for a minute?
just
Just calm
trying
it
to
down for a
understand.
minute. I want to ask this question. Can you identify the complainants and the complaints that you've received? Because I see more than one name in this chronology of events, but they're not clearly called out here. So who are the complainants that brought your attention to this site?
The complaints were received from a Laura Gannon and Simon Dolan, who is her husband.
And are they present in the room? Can I hear from you, and again, I'm not going anywhere except getting all the facts. And can you identify yourself for the record?
Hi, Simon Dolan, 10 Farmstead Way. And to specifically answer your question, the extent of the equipment of this company, it's a large-scale landscape construction company as advertised on their website. Recent projects include Concord Academy quad regrading, Middlesex School courtyard replacement and regrading, big equipment, lots of employees, including gooseneck-sized trailers. This is 18-wheel truck-sized trailers with a cab and a big long trailer. that often transports front-end loaders, excavators, several dump trucks, varying in size. These are the types of things you'd see at large construction sites. That is considered the landscaping equipment. And also so to answer your question, that's the size of equipment that we were talking about. And for the record, Cataldo Nurseries, we've been a neighbor of theirs for 20 years. They've always been and continue to be a good neighbor. I'm talking about Cataldo's Nurseries, the place where we all go to buy our Christmas trees and the distributed products that they sell. Specifically, MJ Cataldo Landscape is an altogether different entity that was operating, to my understanding, without a permit. There's a non-transferable permit for Cataldo Nurseries. But the MJ Cataldo Inc., and the attorney said that they've been a presence in landscaping for over 40 years. To my understanding, MJ Cataldo, not Cataldo Landscaping, MJ Cataldo Landscaping has only been around for 10 years and has grown oversized, which is good, of course, until it gets to the point where it's such a large-scale operation where it was a big operation. And when you refer to soil sifting and things like that, I find it hard to believe that several hundred, if not thousands, of cubic yards of soil is being used for farming. There's no farming going on there. They're essentially a distributor. They were used for these large contractors, these large construction projects that they were doing.
So if I can speak next. When we first moved there, we knew...
Just identify yourself.
Laura Gannon, 10 Farmstead Way. When we first moved there, we knew there was a nursery there, and they had a special permit, and I believe I am under the understanding, we're in a residential district, and they have a special permit to operate the nursery. It's not agricultural. So we understood that we're next to the nursery. The nursery's not been a problem. But then this company started up, and according to the Board of Appeals, you guys said that he couldn't operate a landscaping company out of this same area. So now there's a nursery, a landscaping, and he has another company in there. And when we talk about sand loaming, I'm literally in my backyard in a residential area, and there's dirt in my pool, in my house, on my deck. Every day this summer, there was sifting that was so loud, I couldn't even be on the phone. This has been going on for 3 to 5 years now, the loam sifting and all the really large noises. So when we moved there 20 years ago, it was a nursery. And we're like, okay, it's a nursery. It closes at 5. It's no big deal. Now we've got a big landscape and construction company that's running trucks, dump trucks up and down our road all day long. They're sifting, loud noises. Like I said, I can't even be on the phone. And if you look at the letter, I mean, I've definitely been complaining for a year, but I've been complaining longer than that to Mr. Cataldo in person.
Can I ask a question of the chair? Please correct me if I'm wrong. My memory is that we gave him a special permit to fix some farm equipment and trucks in his building, but he wouldn't need a special permit for a nursery because it's agricultural. Is that correct?
Yeah, so just for the board's benefit, we've been...
I started to look through the letters.
Getting ready for this all week. For the board's benefit, I want to pass out a couple of things that I downloaded that I thought would help you. One thing that Janet passed out tonight is we found that 2010 decision that you and I recalled about granting permission for the repair of certain vehicles on the site. And I think, having heard the complainant's argument, that really doesn't address this. We did give permission for small equipment repair, and the transport of that to and from customers.
Yeah,
And
the
that-
size of the
does everyone
equipment,
have that
not to exceed
decision?
that which can be pulled by a one-ton
Yeah.
vehicle. Yeah, so that was the
And so we
special
gave-
permit.
We gave that special permit, so that really doesn't address the
And that's not an
landscape.
issue.
And then what I did is I downloaded a couple of things from the references in council's letter. I don't have enough to go around and send, maybe you and I can share, and then I got 4 to go this way, and down there you can share, 2 people can share one. But it says, zoning is not allowed to regulate, and it goes on to a list of things, and it says, such things for agriculture, horticulture, floriculture, and things like that. It says, nursery stock shall be considered produced by the owner or lessee of the land if it's nourished, maintained, and managed while on the premises. So I think as far as the nursery part of it goes, everybody is in agreement that that's a permitted use under this zoning, Massachusetts statutory law, which says zoning can't regulate agriculture use. Then the general laws, chapter 128 definitions, go on to say farming, agriculture, and farming definitions says, over here, yeah, they can also do any forestry or lumbering operations performed by a farmer who is defined as one engaged in agriculture. And then going back to the 40A section 3, it says you define agriculture as what I said earlier, nursery stock and the maintenance and management of it. So what I'm hearing people say is there's a point at which no one has a problem with the nursery, and no one has a problem with the harvesting of materials necessary to nourish the nursery stock, and the transporting of nursery stock in and out on Farmstead Way, and the equipment necessary for residential and domestic use to be repaired on site, brought in by trucks to drop it off for repair, and brought out again to deliver it for repair for normal residential household use. And what I'm hearing Ms. Gannon and Mr. Dolan say is that they also have no objection to Mr. Cataldo as a neighbor, but object to the huge, large-scale operation of trucks with gooseneck trailers and heavy equipment that is expanded past the residential or the domestic home occupation landscaper and/or nursery stuff. What I'm also hearing, before everybody winces at me, I'm also hearing that he has grown to that extent, successfully, unfortunately, has recognized it, and has now made plans to move the entire landscape contracting operation off-site.
He's shaking his head no.
Because the landscape operation, there's a point at which the landscape operation belongs with the nursery. He still needs to raise product for the landscaping that he does in domestic residential uses. Am I wrong about that?
That's correct. Yeah.
And I think what your neighbors are objecting to is not so much that you have trucks coming and going with nursery stock and dirt and mulch and even gravel and maybe even stone for the landscaping you do. I don't think the neighbors are as opposed to that as they are to the construction operations. And let me just hear from them if I'm zeroing in on the problem, if I would.
How do we define that, though? Because the gentleman here said that nothing remains of MJ Cataldo landscape that has to do with landscaping. It has specifically just to do with the nursery. Well, with that, then explain how we still have a significant amount of large truck traffic with labels on the truck that say MJ Cataldo, Inc., going up and down the road at various hours.
I'm going to ask the attorney that question.
MJ Cataldo is for liability and business purposes, they separated out the entities. The MJ Cataldo branded trucks are what are used by the nursery to carry out their transportation and installation. They're not going to have any trucks. There are no trucks owned by Cataldo Nurseries. It's a family-owned business. For their business operations, for liability purposes, they had to separate out the entities. And the MJ Cataldo branded trucks are what are used. A portion of them are used by the nursery for their business.
How do you respond to the abutters' complaint that the big gooseneck trailers are carrying big road construction type equipment?
Those vehicles are now garaged in Massachusetts. They've been moved about 30 days ago. They are parked there every day. They do travel back and forth to the property from time to time to make deliveries for support of the nursery. Just to clarify one thing, there is one vehicle that's owned by Cataldo Nurseries. I don't want somebody to go on the website and say They lied. We own one pickup truck that's registered to the nursery. Everything else has a high liability insurance carrier on it for the purposes of transporting materials over the road. That was a business decision that we made 15 years ago, purely from a liability standpoint, and they are affiliated and related companies.
Can you maybe estimate how many truck trips a day that go in and out of the property that are the gooseneck trailers and the 18-wheelers?
I'm gonna let my son answer that one because he handles that.
Want to identify yourself?
I'm Mike Cataldo, Joe Cataldo's son, and that varies. I mean, we all know my business is seasonal, and, you know, that would be, I wouldn't take a venture to answer that. It varies.
Well, your father
day to
just
day.
said the big vehicles, the big vehicles
Sure.
that I'm
Well, I
hearing
mean,
the
the
abutters
point-
say are offensive have moved to air.
Sure,
But
that
they
is.
still have to come back.
That
and
is our
forth.
attention, absolutely, they still have to come back and forth. I would say, you know, let's say over the last 30 days, those vehicles, there's days they haven't traveled up and down the road. There's probably been days that they've traveled 3 or 4 times up and down the road. It varies. I mean, I think the hardest thing here for the board is that a lot of these questions are around sizes of vehicles, numbers of vehicles, and, you know, what portion of the operation is used, and it varies. We're in a seasonal business. And we have done everything we can to be a good neighbor, and that is our intention. But we use this property and we use these businesses to make a living.
Go back to you, Laura, and then I want to hear from anyone else.
I just want to make this is a residential item. This is a residential district with a special permit. It's not agricultural. And I have a Board of Appeals here that it specifically says, the operation of a contract landscaping business not in connection with the transplanting of nursery stock is not permitted in a residential district. This is an excavating company that's pretending to transport nursery stock. And like I said, we've been neighbors with them for a long time, and it's been fine. But it's been increasingly, it's ruining the value of our property. We can't even be outside in our deck. I mean, this is extreme. It's not just transplanting nursery stock.
Has anything changed since they moved some of the trucks?
It has
to
gotten
air?
better. It's not gone away.
Is it fair to say that since it has gotten better and they're not completely entrenched in air, that it's likely that it will continue to get better when they move the large-scale stuff to air?
I hope so, but you know what? This is what happened last year, and then spring came and summer came, and it happened all over again, and I couldn't even go outside.
I just
So
want
don't know.
I just beg to differ. They didn't have air last year, so it's not really the same. They said they would get better.
I hope so. That's speculating.
I want to ask another question, and that is, I want to address what you said, and that is, your assumption or your accusation is that they are an excavating company charading as a landscape company, and we've all been in town a lot of years. All of us know the Cataldo operation, and I would say just the opposite. It was a landscape nursery that has grown and outgrown its landscape nursery size rather than the other way too. They didn't come in as a big, large-scale construction excavation company trying to fool the
But they are
neighbors into
now.
thinking they will. They're getting,
have
they're getting
pictures of
bigger,
what
and
they're
we
doing.
have to address
They're
that.
excavating big pieces of property, like we just said, those Concord fields. That's not landscaping. Those require big vehicles.
But that may very well be landscaping if it's
But that's not
turfing.
landscaping in, I guess what I'm saying is that here it says landscaping is allowed as long as it's only in connection with nursery stock. So now we've got a violation of what you guys
But
put out.
nursery stock, to me, could encompass not just trees and plantings, but turf and loam and gravel and materials and bark mulch. Every other nursery in town is doing all that. I'm not going to argue with you. I'm hearing you. I'm not trying to argue with you.
I know, I just feel like I only have a moment to get through all my
I know,
points.
I'm going to give you as many moments as you want. Let me hear from other people in the
yeah.
room. Anyone else want to speak to this?
So I don't feel alone when you're speaking.
I see a lot of head nodding, yes.
Yeah, my name's Chris Platts, I'm from Partridge Lane, and the complaints, you mention over 1 year, this has been going on for more than 15 years. I've lived in America now for 17 years, and you may detect from my accent that I'm actually not from these parts, and I didn't know how to address this kind of thing. And so my first instinct was to go around and see Mr. Cataldo and inform him of my, my concern about the noise that he was generating regularly outside the operating hours that I thought were reasonable. And I got absolutely no response whatsoever. He showed scant regard for any of his neighbours, and I think the noise generation has just escalated beyond the pale. And so I didn't know how to deal with this issue. Maybe I should have gone to the officials and complained, but I went round several times and I got absolutely no response whatsoever. So any comment that says he's a good neighbour, I take with a big grain of salt.
Where are you? You're on Partridge Lane, you said?
Partridge Lane, yeah.
What number?
Number 1.
Okay, anyone else? Hey, Alan, did you have something?
Well, I'll wait for the audience.
Yes, sir.
Marco Borba, 29 Robinson Road. I've been in that neighborhood for about 9 years now. I previously owned 32 Robinson Road. And Robinson Road is at times used by the employees of Cataldo's to park near the back entrance. There are also trucks that come in and out of the back entrance at times. And I have not found this to be an issue whatsoever. 32 Robinson Road is right next to the nursery. It's right next to Mr. Cataldo's home. 29 is diagonal across the street from them. I found them to be very respectful of the neighborhood and the noise level in the neighborhood. Found them to be very respectful of the 2 children that I have that spend time in the neighborhood and allowing their employees to drive up and down. I also have 2 dogs that frequently roam all over the neighborhood. And I just have the complete opposite experience and have found them to be very courteous of the neighborhood and the noise level in the neighborhood, and have been very respectful of any questions that I've had of their operation.
You know we have a leash law.
I do. I have an electric fence that they sometimes ignore also.
Yeah, it says the woman who chased a wild donkey up and down the streets last night at 10 p.m.
Is that yours?
Yes. Is that your house? Jeez. Yes.
Can I just add on to that? So, while I respect what he's having to say, that's next to Mr. Cataldo's home, and all the operations that are loud, he's pushed to the other side, which is my backyard. So, all of the noise and the operations, they come up my road and are right behind my house. So he's kept it away from his house, which is near Marco's house.
Tell
So
me
just to-
something about the screening operation, because the complaint was that there's a lot of sand and dust in it.
Okay, so when we bought the air property we closed on the air property the end of May. I went to Shelley and Ellen, excuse me, and I said, I need 120 days, that's where we got the 120-day time frame, to screen the balance of the topsoil that is in Littleton, and I will then remove that. As we all know, it rained in the spring. Mrs. Gannon texted me a few times when she was home and made me aware of the fact that she was annoyed that we were screening. We ceased the operation of screening when she was home. I asked her to let me know when she was home. I did not get many texts from her at that point. I then went to Roland and I said, I need a solid 2 weeks of screening in August. And we finished the screening, I believe, September 1st or September 2nd or something like that. There is topsoil that we sell through the nursery, stockpiled on the property. The screening operation has ceased, even though we still believe by right we have the opportunity to screen on the property. However, since we have bought the air property, our intention is any loan processing that will go on in the future will happen in air. There is no dust, there is no airborne particles on the property at this time. Was there dust during the screening operation? Absolutely. No question about it.
But that's gone.
But that is gone.
Alan, you want to ask a question? I didn't mean to jump in.
Yeah, I mean, looking through all of this stuff, I was trying to figure out, where the technical elements really were. And when it came down to, first of all, the hearing about the dirt, and that's really good, because I didn't see that in here before. But what I saw was basically, in terms of time, there was a complaint about the noise starting at 6:50 one morning. I'm thinking, okay, that's a 10-minute margin there that can happen sometimes and maybe could be more diligently addressed. But the other thing was the decibel level. I guess it was tested at 56 when it's allowed to be 50. So we're talking, again, a margin of difference can't that be worked out so that it can be
And also-
within the
It was
margins?
constant.
No, but it doesn't, but it doesn't say,
Constant noise is a problem.
but it says between the hours of 7 AM and 9 PM on all days, except Sundays and legal holidays, and between 12 and 9 on Sundays and legal holidays, that the maximum allowable sound levels for continuous noise in each district shall be as follows: residential 50 decibels. So that's 6 decibel difference from what was actually allowed by statute here,
And
right? So
those-
density or if it's continuous, it is allowed in our bylaws. Just saying, in terms of where the actual difference, where the actual margin of fault or illegality or whatever
I don't know when that
is.
was taken, though. Do we know when that was taken?
Yeah, let's ask the question. Who took the 56 decibels? Was that you? At what hour of the day and what distance?
Property line and.
Well, we were on the property line, we were on the driveway, we tried to get as close into the trees as we could towards September 18th. And it was approximately, I would say, maybe 10:30, 11 o'clock in the morning.
Was that when the screening operation was still going on?
No, we met with Michael, he started his equipment up, and we walked over, and we took actually 3 readings.
When you said started the equipment up, what equipment, Michael?
It's a front end loader.
The John Deere 644, which has now been removed from the property.
But does that have to go back to
That-
load and move things around?
That has been permanently removed from the property, the John Deere 644.
But does that have to be
It will-
brought back to
It will
do-
not be brought back to the property.
Well,
So the deer-
front-end loaders seem
As
pretty.
my-
Other front-end loaders will be on the property. I think Chris referenced the piece that is currently there.
In my letter is replaced
Is it-
with
is
a
it a little
newer,
quieter?
quieter loader.
That loader's in 1994, and the decibel level of that loader is the culprit of the sound. And we have much newer equipment, and the decibel level is much quieter. We did not run any test on it, but clearly they're smaller machines. They have smaller engines, and they do not make as much noise.
I gotta tell you, front-end loaders seem like farm equipment to me.
They are that too. They are
But it's
necessary.
residential area.
It is a farm, and they are more than 5 acres, they are allowed to be a farm. By state law, they are more than 5 acres, they are a farm. That's the bottom line. And they are allowed to be a nursing.
There's 2 things going on. One is the allowance as of right of the farming operation, not just our special permit granting them some stuff. So the allowance as of right of the farming operation is as Ms. Colley is saying, is their right as farmers, if it's more than, as farming. And the statute defines it as no zoning ordinance or bylaw shall regulate or restrict the use of materials, blah, 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 for the primary purpose of agriculture, horticulture, floriculture, or viticulture. Then it goes on and it says, the term horticulture shall include the growing and keeping of nursery stock and the sale thereof, and nursery stock shall be considered to be produced by the owner or lessee of the land if it's nourished, maintained, and managed while on the premises. So as of right, the horticulture operation is theirs to do, that zoning cannot regulate. This board can't say no to that. So where I'm trying to,
I mean, God forbid, he could put a pig farm there, and we couldn't stop him.
well, that's not what we're here for tonight.
No, but
Anybody else?
that's the bottom line.
Anybody else want to speak to this? Go ahead.
I'm Tina DeLong, I live at 1 Farmstead Way. So we're at the beginning of the street. I agree with Laura, it has gotten better, but it is very noisy. It starts at 5 AM, sometimes in between 5 and 7. The employees ride up the street, I know you can't help that. There are a fleet of trucks that go up and down all day long. We do not open our windows in the summer. There is a lot of dust, dirt. I'm a fan of Cataldo's nursery, but it's grown. It's too much.
So let me suggest,
Frustrating.
let me just, it's clear you're frustrated, and it's clear the frustration is coming from the Farmstead Way residents. And I'm hearing enough to say you're frustrated with the operation having grown so large, because it sounds to me like all of you have been there a while and not found them an objectionable neighbor. And it also sounds to me like the Cataldos have recognized that they've outgrown that particular location, and they're going to move some of the more noxious noises and activities to another location. It seems to me like this is the first time the board has had a chance to see it or hear it. I don't care how long you've been complaining about it. First time we're hearing it. And it seems to me that we are not going to put somebody out of business at this first meeting, and maybe we need to negotiate, all of us, a go-forward position that will give us some way to assess whether it quiets down when the air operation is open, and whether we can all live and be good neighbors with some timelines. Maybe we come back and review this. Maybe we get some agreement as to hours of operation of the noisy stuff. I hear you,
I don't
farmers
think
have
we
to
can.
start before 7.
You said put them out of business. We can't put them out of business.
No, I know, I mean, I'm saying it figuratively.
We cannot do that.
We're not going to do that. Yeah, we're not going to do that.
State law would not allow us to.
Right.
They have a right to be a farm, to be a nursery, to do those things. They're more than 5 acres, they're established, they've been there. It's just, we have, that's why I was trying to talk to Roland earlier about what is the landscaping, how can we get this stuff that is, if you're questionable, you're saying you're taking it away anyway, that it's going away, you started taking away, you've gotten most of it done already?
No, we still have to build a building. We're in the process right now of designing and financing a building. We're probably not going to be occupying air until next fall.
Fully
And it's
occupied.
Fully occupied, thank you.
So a year
Right
from
now,
now.
right now, we have people that go there in the morning and they leave from there. They're dispatched from air. All of the trucks that are way over 33,000 pounds go from air. Maybe that's a benchmark that we could utilize.
That's
Madam
good.
Chair.
That's good to start giving us some benchmarks.
And the gooseneck trailer and the dump trailer and the tag trailer are all garaged in air.
They do have to come pick up
And
product.
from time to time, as Michael said, yes, but it's.
And you have
it's-
other companies, I'm sure, coming, picking up product.
Correct.
But that can all happen between the hours of 7 and 7. That doesn't have to happen before 7, is that correct?
There is some activity, as my neighbors have said, that trucks come into the property before 7 o'clock in the morning. My son Michael has now restricted any loading period that happens at Farmstead Way does not happen before the hours of 7 o'clock. We have done a lot of work in the last 60 days to try to mitigate and minimize the noise level that we create. There's no question we've grown to the point that the property is overutilized, and we recognize that. We've been in discussions with Roland for the last year. I've kept him aware of what we were doing. We were trying to buy a property last year, and it fell through. Hence, we were able to purchase air, and we're diligently trying to get that underway.
I had a hand up over here. Can I hear from you?
Yeah, my name is Kiran. I live at the 2 Farmstead Way. I know these Cataldo guys are pretty friendly whenever we talk to them, especially from my side. But I still want to say that in the last 2 years, especially in the last 2 years, I have seen increased noise on the Farmstead Way, especially the big 8-wheel or the big trucks basically. And whenever they move, my windows shake. It's that big. I don't know the decibels, I'm not a technical expert, but I can definitely say that the roads are getting, I see that the roads, whenever they go through, the roads are getting spoiled. And not only that, my windows, and obviously the sound is pretty large. I got 2 kids, fortunately they're all pretty friendly, but the point is, there's so much of traffic that it's pretty dangerous for them to just get on the road, and I'm constantly under watch. for any trucks that move through and my kids are outside. So I just want to say that noise is my complaint. I don't have any complaint with the business that they're doing, but my problem is the noise and the heavy traffic.
How long have you lived there?
I have lived there for around 7.5 years.
Okay.
Before that, I have been in a couple of other places, but this is the first time I was on that kind of a noisy, street.
Okay.
So, Joe, you started to say some restrictions that you would offer up.
Well, clearly, the trucks that weigh over 33,000 pounds that could be construed construction vehicles, they're being parked in the air right now. There is not any intention to bring those back to Littleton. I think the issue this evening is that I would like us to be able to leave here with some clarity about landscaping. Landscaping is grading of land. Do we have big equipment? We absolutely have big equipment. Does it come into Farmstead Way? It does not. And I will beg to differ with my neighbors. We do not make a point of transporting equipment as a dispatching area at Farmstead Way. We don't do that as a matter of course. We have no issue with the fact that we are going to move the larger vehicles and operate our landscaping contracting business that Ron has clearly defined for me about what he's allowing and not allowing. However, I think the important thing is everyone needs to understand Cataldo Nurseries and MJ Cataldo are under the same umbrella. Yes, you can go and pull our annual report and see that I own one piece and my wife owns the other. However, we're two businesses that support one another. We buy from them, they buy from us. And we do landscape support through the nursery. They buy nursery stock for us. We pick it up at the nursery. We take it to our jobs. We utilize it at Concord Academy. We utilize it at Middlesex Schools. These are some of the jobs that our neighbors have referred to that are landscape and construction jobs. We're not trying to hide anything. We're very open about what we do. But I just need to make sure everybody understands there will still be support trucks parked in Littleton, Mass. That support Cataldo Nurseries, that say MJ Cataldo on them.
So-
We're not trying to hide anything. That's the way we set these businesses up.
So you're in the happy circumstances of being successful
Well,
and growing.
depends upon how much the building and
Yep.
air costs.
Yeah, well, that's a different issue. But you're in the happy circumstances. But it seems like it's only in the last 2 years that your business has gotten so successful as to be a problem for the neighbors. Do you think with once you get the air property fully functional, you can get back to the noise level that was of, say, 3 years ago?
Yes, but I also want to call your attention to the
And
fact
traffic level?
that you permitted another use to the property 8 years ago, which is the rental and repair business. So there may be some thoughts that there's vehicles that come into the property that aren't our vehicles. They're going to our tenant to have their lawnmowers repaired. There's many other landscape contractors, maybe there's as many as 10 a day, that come in towing a trailer full of lawnmowers to be repaired.
There's also, I don't mean to interrupt you, but there's also a blurring of distinctions in the decision in 2010 because it says, petitioner presented a request to allow expanded sales of items to his existing special permit, which currently permits sales of hard goods for landscaping applications, and gifts at the farm stand, which sells agricultural, landscape, nursery stock, garden supplies, etc. And it says he wanted to add motorized landscape equipment such as tractors, rototillers, snow blowers. And he said, and we granted that, and it then says, the history of the business and the existing permit were reviewed and the board was satisfied that the petitioner operates a farm stand and landscaping business as of right within the zoning district. That's what we found in 2010, farm stand and landscaping business. And
At the time we granted that permit, the neighbors came out and supported you. And I was your biggest trouble about wanting to make sure that
Truck size.
truck size and, you know, vehicle repair size and keeping it inside and making it, but it sounds like that one hasn't been a problem.
no, that's,
It's hard to differentiate them, hopefully not, but, I mean, when trucks are coming up and down the road, it's hard to say just from that single trip where they're going, or what their exact purpose is. I mean, obviously,
Has that business grown that much?
Well, I'd just like to make one point. I think we're here for zoning issues, so with all due respect, the
This
point.
is a zoning issue.
No, in regards to success of business and size of business, I think the point, and Chris, feel free to jump in, is that we want to make sure that we're here within our zoning bylaw, with meeting the requirements of the zoning bylaw.
no, that's not what you're here for. What you're here for is you're here on the very limited purpose of appealing the decision of the building inspector to cease and desist. This is what it says. Building inspector said, you are to cease and desist the operation of the landscaping business. This board's, the only thing in front of this board is whether or not we think the building inspector was within his authority to order you to cease and desist the
Correct.
landscaping business.
Correct.
And I say building inspector, I know this letter was issued by the Assistant Zoning Enforcement Officer, just to clarify the record. And there is some reference in this letter to noise. And I didn't see anywhere in the letter where the building inspector concluded that the noise exceeded anything or that the noise had to stop, so that's not really in front of us today. The only thing in front of us is whether or not the letter ordering you to cease and desist the activity of landscaping business should stand, or we should overrule that decision of the building inspector. Now, if we overrule that decision of the building inspector, which is within our power to do and all that we can do, we will leave a bunch of neighbors here who are not satisfied with the noise and the noise levels unsatisfied. Because if we decide to overrule the building inspector and conclude, as you've been leaning toward, that all of this is part of
I'm not leaning towards,
agriculture.
I'm trying to understand. I've been trying since the beginning of this hearing to understand what is farm and what is the landscaping business. And I have yet to find a differentiating between them. I guess there's just too much of a blur. I'm frustrated because is the landscaping business the use of his lawnmowers going in and out, or the front-end loader that leaves as opposed to the front-end loader that stays and does the dirt? I mean, they're allowed to have agricultural and nursery use. So where is the landscaping business that you're ordering cease and desist? I don't want to understand.
You want to wait
I
a
wanna
second through
understand
the
where
chair?
the line is.
Through the chair.
I just want to understand where the line is. If you stand, what do you expect them to change?
Madam Chair.
Yes, please.
The board made a decision in 1987, and the language is this: the operation of a contract landscaping business not in connection with the transplanting of nursery stock is not permitted in the residential district. You gave that to me.
Okay.
Now you're asking me to define what you gave to me. So you tell me what you meant.
Could you repeat that? The operation of a landscaping,
This is what's not permitted. The operation of a contract landscaping business not in connection with the transplanting of nursery stock is not permitted in the residential district.
So how do you define non-connection?
Except, excuse me, it's contract landscaping business, and yet in 2010, a subsequent board said, the board finds that the petitioner operates a farm stand and landscaping business as of right. So the decision in 87 said not of contract landscaping business, and the decision in 2010 says the landscaping and agriculture is as of right. So it's a conflict.
So if you look at my memo to the board,
Yeah.
my last sentence is, please clarify this.
so there's contract then let's look at it as there's contract landscaping business, and then there's landscape, nursery business?
But then it says, but not in connection, but they are in connection.
They are in connection.
And isn't it fair that this all arises from the issue of noise?
Noise and dust.
Well, noise
Though
and,
it's not specifically mentioned
traffic.
on the,
And traffic.
Vibration.
Yeah, traffic.
But Madam Chair, if it wasn't for the landscaping business issue, I wouldn't be taking noise readings, because then it would be a truly allowed agricultural use.
And they could make as much noise as they want.
So that's how I jumped to the noise
but
part.
you just said yourself that you consider sifting operations, and you said you consider front-end loaders and bulldozers as part of a necessary agriculture use. And if those are the machines making the noise, they're not regulated.
But
That's
if
what you're
they're,
both saying.
but if
Exactly.
they're being loaded onto trucks, they're not being used on the farm, they're just being stored
not.
there and being loaded onto trucks and taken away, and the noise in problem is from that loading and removing, then that's not
But they are
farm
using
equipment
it.
being there.
Mr. Cataldo said that's not what happened. What's happening is, he's using it. He's
Right.
using it to move dirt around, he's using it to sift dirt. And as a good neighbor, when the noise complaint happened with the dirt sifter, he said, that's an old noisy dirt sifter that probably was built before the regulations for decibel management, and then he got a new dirt sifter.
Mr. Cataldo is giving me
New loader.
The loader is the noise.
I gotta say, too.
I'm sure you do.
It was the tractor that was noisy.
So,
So
And
I
that's
have-
been moved
I
up.
just-
Yes,
So
go
I think
ahead.
this is where I'm struggling too, because everything I read, it says it's a residential district with a special permit for Cataldo's nursery that's non-transferable. So like I said, 20 years ago, I come in here, there's a nursery with a permit that's not transferable, so I assume that this is the only business that can ever operate there. And it's not, I don't think it's an agricultural permit, I think it's a residential,
they don't have to have a permit.
I
for
think the
agriculture.
87
but
decision,
it's a residential district. He's still in a residential district.
I think the 87 decision was not about whether he could do agriculture operations of landscaping and dirt sifting. The 87 decision was whether or not he could open the retail store to sell retail products that were not grown on the land. And if you read the decision, that's what it says. Conducting a retail store and selling articles which are not incidents of the nursery, such as crafts, Christmas tree decorations, garden tools, and equipment. And, I'm sorry, that's the 87 decision. And so they came before us in 87, and I think I'm old enough to say I was on the board then, but my name's not here, to ask us for the retail sales expansion of their agriculture operations. So they are, as of right, an over 5-acre farm doing agriculture and horticulture, and have been as long as I've been here. So the issue is, it's unfortunate that that decision said not a contract landscaping business, but it says, which does not concern the transplanting of the nursery stock. And he's saying that the landscaping business he has been and is doing is transplanting nursery stock. They grow it, they buy it, they sell it, they load it, they deliver it, they plant it, and they grow more of it. And that's all agriculture, horticulture allowed as of right. That's the problem I'm having. And I think one of the problems Cheryl's having is there's a blurring of lines here. Certainly a big, huge, I'm going to pave roads for a living is different than transplanting nursery stock. But I'm going to do the fields at Concord High School is, to me, squarely a landscape nursery operation. And I think the equipment is the same in both instances.
Yes.
Am I right?
I'm sorry, I didn't mean to
No.
do that. Yes, you're right, but then I looked at the board for an explanation as to what a contract landscaping business is, so that I can differentiate.
Yeah, I hear you, and I feel your pain.
You feel it?
I feel your pain, and I feel your pain.
And
And
I
so
feel your
what I would
pain,
like to
because-
get to, what I'd really like to get to, honestly, everybody, and I think it's in the spirit of good neighborliness and goodwill, including yourselves, the Cataldos have represented that they're trying to move the biggest and most offensive portions of this operation. They've represented that financially and permit-wise, it's not going to be tomorrow. It's not going to be in a day or two. What I'd like to ask, everybody's indulgence, is for a continuation of a decision today that his landscaping operation does not have to cease. And we're going to ask everybody's consent to let us overrule that building inspector's determination but to have some timelines for reviewing this on a periodic basis to see if they're keeping to their word of moving the big stuff out and diminishing the noise for you and going back to an operation that is truly landscaping and the nursery stock and the agriculture
And the gift
centered.
shop.
And the gift shop that was permitted in that little, and the repair, the equipment repair that was permitted in that Littleton location. And if we don't see a gradual change, it's not gonna be overnight. I'm reminded of.
I just can't go through another summer. It was awful. It was in my, like, backyard. I
So
couldn't
let's
even
have a
do it.
review before, like at springtime. Now, he's not gonna build a building in the dead of winter, but I have a feeling that he will have a lot of the big noise problem and dust problem out of here over the winter months. I just,
Wasn't one
I'm
of
not
the
gonna
biggest-
forget you, I just wanna also address something. He's got a snowplow business, and those trucks are going to be coming and going and beeping and backing up in the middle of the night if that snow is deep enough and heavy enough to have to move at midnight. So I just want everybody to leave this room understanding that that's gonna be part of this too.
Oh, the backing up beeping is one of my pet peeves.
Me too.
Can you disable that?
No.
Oh, we all hear it on our road.
If you want to violate state law, you can.
State law.
If I may make a suggestion on that?
Can, this, last summer, one of the biggest problems was the dirt screening, correct? No, it's the
Are you
young
talking
lady.
about-
That,
I mean, that's what led us to this,
No, that was
the
the-
last few years.
That was the
It's
last
really
straw.
the last
okay,
straw.
so that's moved. So maybe, in any case, you won't go through a summer like
The
this.
problem is that I thought the intent would be to make it better, and it's just taken so long. So I'm worried that it's not.
Frustrated.
Yes,
Well, that was-
frustrated.
So why don't we come back in May?
Fine, Chair,
By
if I may.
May, things have shaken out a little bit, you can be a little, you think you'll be totally or ready to occupy by fall of next year. By May, things should have improved. We're not looking for perfection in May. We're not looking for what was 3 years ago in May, but we're hoping that things have improved by then. Can we live with that?
Let me hear from
That's
Mr.
fine,
Dole.
Simon Dillon, 10 Farmstead. I've known the Catawbas for 20 years, and despite all this, I still consider them friends. I am concerned, I guess, in light of all this, the proceedings, everything else, everything we've been through with them, the concern of mine, and maybe this can dissipate via the work of the board, the concern of mine is if it is revoked, or if the appeal is accepted, what recourse do we have based off of all the information that you've seen from us today? It seems like, how definitive can we be, and over what period of time?
Right, Alan, want to speak to that?
Yeah, I mean, I would like to see a proposal for mitigative measures to address the four things that I see as the particulate that's in the air, or that was in the air, the noise, the timing, and the vibration or tonnage, restriction. I'd like to see some kind of mitigated proposal that we see before May, that could then be, that we could at least have some response to. And then in May, there'd be some testing that might be done to sort of, substantiate that you've actually made these measures and whatever, because I think that's kind of where your out's going to be, is sort of addressing those specific technical issues. And so vibration we've heard particulate, we've heard decibel, and we've heard time. And those things are very specific, so if you could address those in a sort of an aggressive way, I think that would go a long way to solving some of the issues that we're hearing over here.
So I want to just respond to that. I don't think the mitigative measures should be proposed or adopted tonight. I think that the Cataldas need some time to think about them and really address what you think the things are that you can live with. I also think the neighbors aren't going to experience as much distress now that we're heading into winter months, just by nature of the season. So I think we can get through a few months of the winter where they will have a better idea of their building and time plans. So I sort of agree that before May, we should have a mitigation outline that everyone can live with. But that doesn't have to be this week or next month.
I was suggesting early in the year.
And I also agree with Mr. Dolan that if we side with the applicant against the appeal.
With the appeal. We side with that one.
With the appeal, against the building inspector's cease and desist, I kind of agree with you that we should have either a continuation where we temporarily lift it and come back to it, or where we lift it but we have a review, during which, if you're unsatisfied, the building inspector can issue a new order. Is that a way to solve
I don't think you
this?
can just say unsatisfied, because they have a right to make a certain amount of farm noise.
I agree with you. I apologize.
So what we need to do is have a review. I think a continuance, a temporary lifting is an excellent idea, and a continuance, but I think.
I don't want to temporarily lift it.
No,
They hired counsel, they came here, they've addressed the case, and we have taken a position that the landscaping operation is part and parcel of the agriculture. I think to clarify for the building inspector, we've all sided or erred on the side of the landscaping operation is here to stay. I think your point about noise, dust, vibration, and heavy equipment.
And schedule.
And schedule. And if you want to write those down, those 5 things need to be addressed in some mitigation fashion. And then, when we come back for a review of the matter, let me just think about this procedurally. If we grant their application and find against the building inspector, do we?
I hate finding against the building inspector.
I know, but do we still have any jurisdiction over this?
I hate finding against the zoning officer.
Can we get a voluntary bringing it back so I don't have to hold anything over your head? I mean, will you agree to come back in April, like to address a mitigation
Could I
plan?
address a couple things
Yeah.
first? First, Mr. Bell, a significant part of this is that they have done a lot of mitigation over the past few months. And they've done that mitigation to the point where we believe that they operate under the bylaw and under the statute as their right to operate at this time. And they will continue to move more of the operation to air, but we believe that even now, they operate as an allowed use, that everything that they do, that everything that happens currently is allowed as of right. And, I mean, it just a matter of their operation, it will continue to move.
I appreciate what you're saying, but I also stand by what I suggested. So you can take it however you want to, and you can take.
Could you say those one more time?
Well, the areas are the dust, particulate, right, that can be measured, the decibel level, the timing, in terms of scheduling during the day, the hours can be addressed. Doesn't have to be exactly here. It could be more aggressive than this in terms of maybe not starting until 8 or something. I mean, there are things you could do to be aggressive, and I think the 4th thing was tonnage or vibration going up and down the street. So it's up to you as to how you want to propose.
So the logical conclusion is, let's hypothesize, we agree with you and we send you home. There's nothing to keep your neighbors from calling up tomorrow and saying he's noisy again. These complaints won't stop unless we all sit down together and find a mitigation solution that everybody can live with. Nobody's going to be completely happy. That's the best negotiation you can have. And that's where I'd like to see it, because they're willing, I think, to say, we'll stop complaining when you show some positive signs of reducing the problem, right? And I think that's what I'm seeing your heads nod.
Well, I just, like 20 dump trucks came up the road the other day, and another big vehicle, so I still am not really happy with that. So I'm happy with a lot of what's been changed, but I'm still like, why is there big dump trucks coming up and down my
But if
driveway, and other big trucks for...
But if they're so successful that it takes 20 dump trucks to deliver their nursery stock during this season...
I guess I'm not buying that.
But if it is, just assume that it is. How can we say to them, you can't be that successful? You can only have 10 dump trucks.
I mean,
We
I'm
can't
still
do that.
Exactly. I think it's gonna be hard to define that for them.
You can't quantify it.
No.
What we can quantify is noise, dust,
I
the
mean, if you have an 18
vibration.
wheeler moving a tree, then
The only way we have any control over the noise and dust and vehicles is if we say it is a contracting landscaping that there is some control, because if we judge it to be purely agricultural and nursery, we have no control.
But it
We
says
have no right.
contract landscaping not in connection with nursery.
And
But
this
it is in connection with nursery.
connection with nursery.
So
But
we
not if
can't,
you go to their website or their Facebook page, or they're not, I mean, this is,
it's a headache.
yeah.
If the definitions are a real headache, and we have to be careful of state law, because state law says that they are allowed to be a farm, and they are allowed to be a nursery, and they are allowed to bring in stock and sell stock and move it out, including rocks and dirt and all of that junk.
It could be 40 trucks a day, and there's nothing we can do about it.
But on the other hand, we can say that they can't run accessory businesses out of there, other than the one we already granted, which we can't suddenly pull the rug out from under him on, because we've granted it. So that's what Roland is trying to do. He's trying to say they have to cease the contracting landscaping. But it's really hard, I'm having trouble
As
seeing
long
the
as it's
line.
not in construction with nursery.
I think that they've
Which it is.
demonstrated a willingness to do something about the hours, do something about the heaviest trucks being off-site, do something about having their dispatch come and go from here. Look, quite frankly, they don't want to conduct a business of this size with all of you calling the building inspector every week or every month, or the police. Why would they want to do that? But they need to get air open in order to be able to work out of air. They need an office and a building and a place to have their invoices and their phone calls.
We agree, we just don't,
Okay.
we don't want this to end if it's still like this.
Okay.
I mean, that's, I'm
So,
concerned.
so because there's limited things we can do, we're asking for your patience again, because if we can only control them so far, and that's very limitedly. So having their buy-in and their approval and their willingness to help is very beneficial.
Yeah, can we take a 2 or 3 minute break? I need
water.
Bathroom, some water. Anyone else want to stretch for a minute? And 15 Great Road, do you wanna?
15 Great Road's not here, remember?
No, she said, she told him not to come, and that we could make a decision tonight. Maybe I'll just take that quickly through the middle. Yeah. Just so that when we're done with this, we can all go home or drink or whatever.
Bathroom's that way, yeah.
Yeah. Yeah, we're gonna suspend this hearing. I need a motion to suspend the hearing for 5 minutes. Second, please. Second. All in favor of suspending for 5 minutes? What? Okay.
To say aye. We're suspending for 5 minutes.
Now I need an agenda. I can't till everybody comes back in. Okay.
It seems like the language in 1987. The reality of the industry at the time, and that they weren't doing outside landscaping, it was strictly limited
They were, but they were like, you know, Joe and Schmo's house.
to. Yeah.
And now it's like, they're getting
It's every, right.
that still are integrated with the nursery.
Well, it may or may not be. Don't you get jobs that have nothing to do with buying the stuff at my nursery? It's jobs of doing landscaping.
Yeah, but they're buying
independent
their
of it.
materials. Yeah,
Right.
but I think
So-
there is more, like if you walk in at the point, all those flowers, that would be
I'm not trying to beat up on you, it's just, I don't understand what the difference is with contract landscaping.
That's not the noise problem.
So the noise problem is.
Yeah, but they need the loan for the nursery. But they're gonna do it here. Right, that's what I'm saying, but they don't have to.
They don't have
I feel
to.
like
No,
he's
no,
wording.
No, they don't. So the other issue.
But they've already moved it, so they're going to. They're not gonna be coming back to live.
But the other issue of all the trucks, so when they buy a bunch of fruit trees in the spring to sell to you, me, and everybody else, they don't even come on his trucks, they come on somebody else's big flat.
No, it's been growing.
Yeah, but I
Loads them with
understand
the
their
front end loader.
I've had
So
less
some of these
patience with them
vehicles
than they just bought.
going during the day are not
But
even.
they've been there a while.
Not at all.
Right,
Growing.
Delivering stuff in
Like, I'm frustrated with 495.
And they're buying a whole bunch of trees and they're bringing them away.
Or someone's, it's a
You guys getting martinis and give me one?
We have a request for 15 Great Road, 8 o'clock PM, case number 795B. Determination of whether a proposed change to the signage is a substantial or insubstantial modification of the 40B comprehensive permit. Under the statute, 40B statute, any change to the 40B approval comes before this board. The board has to first decide if the requested change is substantial or insubstantial, and if we determine it to be an insubstantial change, we can then hear it and have them petition us. If we determine that it's a substantial change, we have to give all the notices, 30 days notices and everything else. So I think they're just requesting a sign change,
Yeah.
Yeah.
and I'm not sure if we...
It shows the
It doesn't
existing
even look
one.
like it's the same, looks like the same size, they're just changing the.
Same verbiage with a flower.
Yeah, but I don't think we can approve the sign change on a sign. I think tonight we can only vote as to whether or not that's substantial or insubstantial, and then if they want to present their sign change to us, then we can vote that. Is that what you left them thinking, or did they think that we were going to vote that sign tonight?
No, I just wanted to know if you consider it substantial or
Yeah.
insubstantial.
So I'll
Is
take
the
a
sign getting
motion.
bigger?
No, the sign is staying the same, it's just the panels of the sign. Village Green has a new management company, so they just changed their logo to that little leaf.
Oh, that's no, because the same verbiage.
And the Wildflower Meadow logo, I believe, is still staying the same.
Okay, so I'll take a motion to,
That we consider the change that's been proposed to be an insubstantial modification.
seconded by Rod. All those in favor signify by saying aye.
Aye.
Okay, now they can come before us and present it. Okay, going back on the record on case number 910A, 7:40 PM, Joseph Cataldo's request for an appeal of a decision of the zoning enforcement officer.
All right, one thing I wanted to mention is that we do have a letter from another abutter, that couldn't make it tonight. I don't know if you would want to take it, would be able to read it in or not.
Yep, we can read it into the record.
Do you want me to read it?
Yes, please.
All right. To whom it may concern, I'm writing this letter to address concerns about noise coming from Cataldo's gift and garden. My family, me, spouse, our son, and second due in May, have lived next door to Cataldo's for over 4 years. We moved to 34 Robinson Road with the intent to put roots down in Littleton and grow our family. We have loved every minute of life in Littleton and the community on Robinson Road, including the Cataldos, is one of a kind. Living next door to a landscaping company, we were a little concerned about noise when we moved in, especially when our son was born and I was home on paternity leave. I wasn't sure if you'd be able to nap okay during the day. Honestly, it's so quiet. My spouse and I are not shy, and we would certainly complain if there was noise, but there's nothing to complain about. The Cataldos are incredibly respectful, nice, and welcoming neighbors. We couldn't ask for a better family business to be next door. Please do not hesitate to contact me if you have any questions or need information. Joel McCarthy Latimer, and that's 34 Robinson Road.
Okay, and in the interest of saving time, because it's snowing out and we all want to move along, I heard you say over in this end that that's Robinson Road and the activities that you're complaining about are farmstead. So we'll just put that into the record too. Thank you for reading the letter. Okay.
So another aspect of what I spoke about with my clients is that if we, again, have to reiterate that we believe that what we're doing is as operations as of right. If our appeal is allowed and the decision is overturned, we would be willing to work with the building department and complaints they receive to try to see if there's something that we can come up with, and then review it in the spring, sometime in May. That is something that we can agree to now.
Question, Madam Chair.
Yep.
If we overturn the zoning officer's ruling and the complaints continue and next spring or summer isn't any better, can the zoning officer reissue the cease and desist and bring us all back here the same way?
Yes and yes, because he would have to do it under noise. You can't do it under noise.
It's agricultural use, what am I gonna go after? It's farm equipment.
What about the dust and air pollution?
Farm equipment, you gonna do that to Matheson?
Especially when he spreads his manure?
What if you came,
They own this big equipment.
what if you came back with another cease and desist that you consider the operation to exceed that used for nursery and agriculture use?
Whatever you want.
I want to leave these people a venue, an avenue to go down. But I also recognize a nursery business is a nursery business and a farm is a farm. So, but there should be an avenue for them to go down. They didn't buy into what it is today. They bought into what it was 7 years ago, 3 years ago, whatever.
Yeah, but, I mean, you can't say
It's
that
gotta
about a
grow.
farm
I mean,
either.
if you buy next to me and I'm a pig farmer and I expand my
But
operations.
this is a separate legal company, and this is my problem.
I'm hearing you, and we're not altogether convinced as a board of that. So I'm hearing you, but I still think that we need to act on the petition before us, and the petitioner and council and building inspector all are in agreement that they're willing to come back to the table with some proposal for mitigation measures, and hopefully in 6 months' time have some more resolution to this. And they're willing to come back and let us review everything in 6 months, so that would be the venue at that point in time. And I think we need to all act on good faith that they're going to do the best they can to stop having to have an adversarial relationship with their neighbors. And I can't say it any other way, that some things have to be done. I think that if I had a pig farm and you were all complaining and you all lived, downwind of me, I would do something to move my pigs to another side or put up a larger fence so you couldn't smell them. And that's what I think these people are trying to do. And it's just not going to happen overnight. So can we all live with that?
I just want to make sure there's an avenue and a venue.
Well, we're still
I
bring them
keep
back
thinking
in
if we
6
just do
months.
a continuance to 6 months, then we have the avenue and the venue, and it's much easier.
No, because personally, and the board can all say whatever they want, and we can pull you all, personally, I don't think that we have any right to stop the landscaping business, and we need to take that move tonight. We have to act on that tonight. That's my
And
personal
there's a
opinion.
practical matter. What is the differentiation between the landscaping business that cease and desists and the ongoing business that is allowed as of right? I don't think we have the way of making that.
I think what our Mrs. Gannon was trying to say was that anything that's listed as MJ Cataldo, which they make a good case it's the same entity, would be the contracted landscaping business and should only be there to pick up or drop off stuff.
And
what
the,
she's
and the
saying.
attorney argues, and I'm buying it as an attorney,
It's the
that
same
you
business.
separate your ownership names so that if somebody's suing for a truck accident, they're not gonna get everything.
There's also nothing to stop a farm from hiring somebody else to come in with their
Yeah.
big piece of equipment
Yeah.
and make noise on their
Yeah.
property. They're allowed to do that.
Yeah.
So whether
Oh,
it's.
farms all the time.
But I am.
So there's nothing
And
different between
But
that
I'm-
and.
As I understand it, the majority of the landscaping business has moved to air.
Yes,
And
and
is no longer in those.
I'm encouraged by the fact that they went out and bought a building in order to do this. they're in the process of doing it, they have moved some of it already, we're all encouraged by that fact. And I think even the neighbors, I mean, you're reluctantly, but you're nodding and saying that you're gonna give them the benefit of the doubt. They're
Stop the noise,
expressing
stop
their
the-
willingness to help out, yep,
Can I ask a question?
yep.
You keep-
Identify for the record, please.
Rena Keith, 6 Farmstead. Prior to, our houses were built in 1996. You keep going back to 1987. The nursery was, and that's when they applied for the permit for the nursery?
No, they
Applied
applied
for
for
retail.
a permit to sell
Retail.
gift
But
items.
Nursery was there
When
before
was
that.
Farmstead Way made?
It was their driveway originally.
It was done
was built
after all this
That came
activity.
into the nursery.
Yeah, they were there first.
That was always
They were
the
there
access
first.
I'm
to
just
the
saying,
nursery.
could a mitigating, potentially, solution be an alternative route, like Robinson Way?
Yeah, but then you're creating the problem on someone else's.
Well,
So,
They're all happy over there.
Identify
can't
for the
say
record.
not my backyard.
Joe, 1 second, identify the record.
33 Robinson Road. I'm also a Cataldo. I grew up on this property, but I am now a neighbor of Cataldo's. The layout of the property, Farmstead Way is the entrance. I am one of the closest abutters. All of the equipment on the property, I am probably the closest abutter, excuse my emotion. But I think that organically, the way the property is set up, where the buildings and structures are, Farmstead Way is the natural entrance. I think that they've done nothing but respond positively to the complaints that have been made.
I think they're trying to. We had a case like this not long ago up in my neighborhood off Tehanawan Road. And the fellow had all the proper permits, and he was doing everything within the confines of the law with a couple of setback issues that we addressed right away. But it was very similar, and the people were complaining about the dust and the noise and the berms and the unsightliness and everything you're complaining about. And the bottom line was he had a right to screen loam there, and we brought the DEP in, we brought the state in, we brought the environmental people in, and the loam screening. There was a piece of the operation that was composting that we got rid of because the neighbors were complaining. But the loam screening was as of right. And so some of these things that you're speaking about today are clearly established as of right by law. And I think that the best way to handle this is their willingness to come back and your willingness to give them a chance to prove what they're saying. And the building department not being offended if we overrule them. I think that's the right result today. Well, it's your first one. Is it okay if I overrule your first one? Yeah, yes, sir.
I just wanted to offer a point of clarification. It was mentioned that the large equipment was being used only on Farmstead Way. And I just want to point out that on Robinson Road side of the property, they store large quantities of mulch. And front loaders are used in that area to pick up mulch and put onto trucks. So I want to make sure that everybody understands that we also have some big equipment that is on our side of the road that we can hear, and it hasn't been an issue.
And it has, and just, one more time, your name for the record.
It's Marco Borba, 29 Robinson Road.
Okay. So, thank you all for your respect here tonight. I really anticipated a much more contentious hearing. I'm going to take a motion to close the hearing.
Move to close.
Second?
Second.
All those in favor?
Wait a
Wait a
minute,
minute. Oh,
you still have to vote.
oh, you close the, okay, just close this
Closing
one.
the hearing, yeah. All those in, you thought I said
Yeah,
no.
I think-
No. All those in favor?
Aye.
Aye. Opposed? Okay, now I'll take a motion on the decision we have to make tonight.
I move to rescind the cease and desist order as ordered by the, whatever the title is.
Zoning.
Building department.
Building
Zoning
department,
officer.
with respect to the
Close it right down.
563 King Street,
Just grant
Application.
the applicant's appeal.
grant the applicant's appeal.
now, are we conditioning it?
With the understanding
With the understanding
that
that
the applicant will voluntarily come back to this board.
okay, sounds good.
Let's say 6
That
months.
the applicant will voluntarily come back to this board. I don't think we've specified.
months.
In 6 months, okay.
Well, we'll
6
say,
months.
you wanted April so that we can do something by May if
5
there's a
months.
need to, right?
So by April.
So let's bring him
yeah.
back in April. Is that all right with you?
What's wrong with May?
They want a chance to
Snow
have
on
you
the ground.
implement in May. And
I'm
not
sorry,
with-
I can't hear you.
They want a chance to have you implement something by May, if necessary, and not by June. Because they don't want to go another summer with, I mean, can you live with that?
Okay.
Yeah.
It's the third week in April, so it's almost May. With a little luck, we won't have anything else before us, and we'll put it off till May. You all right with that? And then, I'm not going to ask anybody to do additional notifications. I would ask everybody to calendar yourself and then check when our April meeting is and see if it's posted on the agenda. Okay, please? All right with you?
And if you forget, that means that they are really behaving themselves, and you're happy.
That's true.
And if you don't show up, we won't be unhappy for you.
So can I have a second to the motion, please?
Second.
That was Jeff. All those in favor?
Aye.
Thank you. Thanks for your time.
Even though I don't think there was any there, that's second.
Oh, my gosh. All right, I move to close the hearing? The meeting? To adjourn. To adjourn?
Second. All those in favor?
Aye.
Specifically, 85.